we're good.
I declare open this hearing of the Senate Economics Legislation Committee into Treasury Laws Amendment 2022, Measures Number 4, Bill of 2022. I begin by acknowledging the traditional custodians of the land on which we meet and pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander people here today. The committee will be conducting today's hearing via video conference, teleconference and in person. These are public proceedings, being video streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. The Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Commonwealth officers appearing today are also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised. A copy of the order is available from the Secretariat. I remind committee members and witnesses who are appearing via video conference and who are not speaking to please mute their microphones. I now welcome in-person representatives from the Tech Council of Australia. So welcome, Mr McMahon. I understand that that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, would you please state your full name and the capacity in which you appeared today?
Mr Tom McMahon, representing the Tech Council of Australia.
Thank you. I now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Thank you, Chair.
Thank you.
Thank you to the committee for inviting the Tech Council of Australia to appear before today's hearing. The Tech Council views our tax and investment system as a key lever to help enable the growth of the tech sector in Australia and lift the wide-scale creation and adoption of productivity-enhancing technologies and skills. We therefore welcome several of the measures contained in this Treasury Laws Amendment Bill. Our focus is particularly on Schedule 2 on the taxation of treatment of digital currencies, Schedule 4 on the technology investment boost, and Schedule 5 on the skills and training boost. Firstly, we support the minor technical change that's been put forward in regard to digital currencies. This technical change continues an existing ATO ruling that Bitcoin and other digital currencies are not treated as foreign currency for taxation purposes. This simply reinforces the status quo and seeks to address any industry or investor uncertainty that may have arisen due to the adoption of Bitcoin as legal tender by the government of El Salvador. We look forward to working with the government on the broader tax and regulatory changes that will be necessary to enable Australia to be a leader in responsible and trusted digital assets innovation. Secondly, we support the introduction of the technology investment boost and believe it can be impactful in driving the adoption of productivity and security enhancing technologies by small businesses. This is critical during a time when small businesses facing rising costs due to inflation and energy prices, while simultaneously being the target of increasing cybersecurity attacks. As set out in our submission, we recommend that the measure proceed, but note that the 30 June 2023 end date is likely to substantially dampen the impact of the measure, particularly given many small businesses have already set budgets for the period of the boost. Extending the measure for a further 12 months would be helpful to maximise the objectives of the boost and provide small businesses with a longer lead time to plan and invest in new technologies, particularly in light of the fact that the legislation is only currently before the Parliament and is due to, that measure is due to complete at the end of the financial year. Finally, we support the introduction of the skills and training boosts, but recommend further consideration is given to what would qualify as eligible expenditure. Specifically, we recommend that eligibility be expanded beyond registered training organisations to encompass other important providers of training. We see an expansion of eligibility as important for three reasons. Firstly, under existing tax rules, training by providers not registered by the relevant regulators is already eligible for a 100% tax deduction. We believe it's important to maintain this arrangement for the 20% tax boost to avoid any distortions to the market that could disincentivise small businesses from selecting training that is best suited to their needs and the needs of their staff. Secondly, it would reflect that training that small and medium-sized businesses commonly use to upskill and reskill their staff, with over 42% of small businesses and around 70% of medium businesses reporting using non-accredited training, which they say is more job relevant, tailored and cost effective. Popular online training platforms for SMEs, such as Australia's Go One and With You With Me, would be excluded by the current bill. Thirdly, it would better support digital skills training, which is now critical for the effective running of a small business. Research shows that shorter courses and micro-credentials often provide more job-relevant digital skills, reflecting that VET courses in IT are in many cases not up to date with industry standards and expectations. Thank you, and I'd be pleased to assist the committee with any questions that you have.
Thank you very much, Mr. McMahon, for those opening words on those schedules of the bill. I'll just kick off with a couple of questions about Schedule 2 and then come to you, Senator Bragg. This is a fairly discrete minor measure, Schedule 2, in relation to the taxation treatment of digital currency. Your submission notes that ensuring tax rules are clear and fit for purpose is important to support the growth of a responsible digital assets sector in Australia. Why is this particular discrete amendment important in that light?
I think given the fact that there was the existing ATO tax ruling that had clarified the treatment of digital currencies with respect to the foreign currency taxation treatment in Australia, that has existed for a number of years, going back to 2014, and effectively was only changed by the policy settings of a foreign government. We think it makes sense to provide certainty by continuing that existing treatment. As you mentioned, it's a relatively narrow measure. We don't want to overstate, I guess, the importance of this for the sector. However, in a time of pretty significant change and uncertainty, we think that it's simply a prudent thing to do to clarify in law the existing treatment from the ATO's ruling.
Yep. Thank you. So as you've said then and in your opening statement and in your submission, this is a fairly a narrow measure and one that you've just described as a sort of a prudent measure, a bit of a sort of clean up. But looking at the broader picture, what role do you see Australia as having in digital assets innovation if we do get the policy settings right? And our policy settings are, as you put it, sort of responsible and trusted?
Yeah, look, this has been an area that the Tech Council has done a significant amount of research into. We think that Australia already has an excellent reputation as a provider of financial services. We have an excellent reputation for our regulatory framework. We have strong regulators. We have a functioning parliament that's able to legislate and make changes where necessary, as evidenced by this measure in this bill. We believe that we can take advantage of that strong regulatory framework and reputation to develop a set of regulations that provide certainty for investors and protections for consumers, so that we can see an industry grow in Australia that has that reputation for being trusted, for being responsible, for protecting consumers, which we think is not only necessary and desirable from a policy point of view, but is also, I think, an essential precondition for the industry to be successful.
Yeah. Thank you. Senator Bragg.
Thanks very much, Chair, and good morning. Look, thanks very much for coming today, Mr. McMahon. I just wanted to ask a couple of questions about the foreign currency issue, but also about the training boost. So do you think it's a good idea for the Parliament to cherry pick out this issue on El Salvador and potentially some other jurisdictions before we complete our own set of regulations?
So is the question essentially, do we think it should have been sequenced in a different manner?
Well, I'm just wondering if you think it's a good idea to cherry pick this issue. Yeah, that's the question.
So the existing, treatment of cryptocurrencies with respect to the foreign currency regime was already settled in Australia by virtue of the tax ruling. That certainty was disrupted or undermined, I suppose, by the decision of the El Salvadorian government. And then subsequently of the Central African Republic. Effectively, all this measure does in our eyes is return that certainty that had previously existed. If the tax office hadn't made a ruling and there was no consistent treatment on this issue, then I think we could have a discussion about whether this would be the first reform area that we would choose. But given that that there already was that tax ruling, and effectively this measure simply reinforces the position that already existed, back a considerable period of time. We don't see any issue with a small legislative fix effectively that clarifies that treatment.
Okay, and do you know how much money you think this will raise, or should we ask that to the Treasury?
My understanding from reading the explanatory memorandum is that there was no financial impact from this measure. I think that's probably best directed to the Treasury. Yeah.
I don't know, I just thought you might have had a view. I don't know. All good. Thank you. Now, and obviously, I imagine that Tech Council, as you've noted in your submission, wants to see the broader suite of regulation on digital assets, don't you?
Absolutely. As I just mentioned in response to Senator Walsh's question, we believe it's both essential from a policy point of view to protect consumers, but to ensure investor certainty that we have an established regulatory regime with relation to cryptocurrencies, but digital assets more broadly. We note the work that you have done over a considerable time in the Parliament on this issue, and we welcome that work. We've noted your private senator's bill on that, and so yeah, absolutely, we think it's essential. We don't believe that we can have an industry in Australia that doesn't have that regulatory certainty, and we think that is the expectation also of Australian consumers of these products.
Well, look, I don't want to labour the point, but we had Senate estimates last week, and the Treasury gave evidence about the progress of these reforms. I don't want to kind of give you a gotcha question, but were you aware of any of that?
I confess I was not watching Senate estimates to that level of detail.
You really missed out.
Okay, well, I might get you to take on notice then, because I might just ask you on notice just to maybe review that element of the tape and tell us whether you think it's achievable, given what was said, that we will have a regulatory regime in place in this Parliament. Because my sense is that the government's talking about this token mapping initiative happening, and then dealing with the regulation of markets and custodians and all that, maybe next year, which suggests to me that might be something for the next Parliament, which would be then locking Australia into the slow lane. So can I just get your take on what you think is going to be achievable in this Parliament based on the evidence presented last week?
Yeah, absolutely happy to take that on notice.
Yeah, thanks. And look, just finally, because I'm conscious of time, so look, on the skills and training boost, I can't say I'm an expert in this area, but are you saying that you think that there should be a broader application?
Yeah, that's correct. So the measure in the legislation effectively limits the expenditure that can be claimed under the boost to training that is provided by a registered training organisation. And our position is that that's not a requirement of the current tax rules relating to deductions relating to training. And it also doesn't reflect the pattern of how many small businesses actually procure training and who they procure it from. So, we believe that it would be both in line with the policy intention of the bill to encourage small businesses to undertake training if that eligibility were extended more broadly so that it covered all training, not just training provided by registered training organisations.
Okay, okay, so effectively you're saying you think it should be expanded to help small businesses access the training that they want to access for their staff. Is that right?
Exactly right. We think that, small businesses are best positioned to make the judgment about what would provide them value for money in terms of what they decide to purchase in relation to training.
Okay, so can I ask you on notice to come back with the proposed, I know you've given a recommendation here. So you've said, okay, but this is your recommendation 3. Support the introduction of skills and training boosts, but expand eligibility to include content provided by organisations that are not registered by ASQA and TESQA to ensure the measure is better targeted at supporting the needs of SMEs and improving digital skills. A lower expenditure cap could be applied for this content to reflect the courses from non... Okay, so look, can you just come back with some proposed sort of drafting that you think would work? Are there any risks here of, are there any risks here of expanding it?
Look, I don't think there are particularly strong risks. As we said, under current tax law, you can claim 100% of the expenditure that you procure for your staff or to do training. It's just for the extra 20%. So there's already the existing integrity measures that the ATO apply to any expenditure. And so, I don't really see what the public policy risk would be of extending this to other training providers.
Okay, well, look, if you could just take on notice what drafting we need to consider to achieve that. I mean, because I think your recommendation is clear, but we might just need a little bit more detail.
Yeah, absolutely happy to take that on notice, Senator.
Thanks, Mr. McMahon. Thanks, Chair.
Thank you very much, Senator Bragg. That actually concludes the questions that the committee has for you this morning, Mr. McMahon. We really appreciate your attendance. Thank you for appearing as a witness today. The committee has agreed that responses to questions on notice should be provided by close of business Thursday, 23 Feb. Again, thank you very much, and you go with our thanks.
Thanks, Chair.
Thank you. Yeah. It's our understanding that blockchain and Gadens are appearing together. Is that what? Yeah. So we'll call Gadens up as well. Thank you. I now welcome in person representatives from Blockchain Australia and Gadens. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard, will you please state your full names and the capacity in which you appear today? And we might start over at the left there with you, Mr Hennessy.
Thank you, Senator Walsh. My name is Liam Hennessy. I'm a partner at Gatens Lawyers.
I'm Lachlan Robb. I'm a lecturer with Queensland University of Technology.
Shane Chandra. I'm Head of Legal and Public Policy at SwiftX, a digital currency exchange.
Greg Vales, Blockchain Australia Treasurer.
Gordon Little, Head of Policy at Blockchain Australia.
Great. Thank you all very much for being with us today. The representatives from Blockchain, do you have an opening statement that you wish to give? And I'll just check as you're doing that whether the Gatens group had one as well. Okay. Yep, go ahead. Thank you, Mr Little.
Thank you, Senator. And thank you for the opportunity to appear before this committee and for the government's commitment to develop a digital asset regulatory framework that encourages innovation and investment while providing appropriate consumer protections. By way of background, Blockchain Australia membership base consists of over 120 cryptocurrency and blockchain-centric businesses and 100 individuals across multiple verticals. With me today is Greg Vales, a board member of Blockchain Australia and the Treasurer, and founder of Vales Accountancy. He provides, among other things, specializes in tax and accounting in the digital asset space, which is very relevant to what we're talking about today. While the recent events at FTC are disappointing and shout a cast of some dispersions on the industry continues to grow and is very relevant. And a good example of that is the investment trends report that came out this week that showed that 10% of Australians have traded in crypto assets. And in the token mapping paper, we see that they're expecting over 1 million Australians to have gains or losses in crypto on their tax returns for 2022. So it's a very relevant and topical area that we're covering. I think key to that is the ability for government to provide clear and transparent rules for how taxpayers and their advisors have to operate in this space. I think our key point in Schedule 2 is just that there wasn't broad consultation before it was released, that it is in advance of the token mapping exercise and the Board of Taxation reviews, and I note that the Board of Taxation is speaking after us today, so maybe we'll get their views as part of that. And that given the nature of this ecosystem, that it might be premature to have Schedule 2 released now, pending those other inputs into what the legislation needs to look like. And I might just hand over to Mr. Greg Vales for a couple of minutes just to comment on what he sees in actual practice, if that's okay.
That's okay, yep.
Thank you. Thank you, Senator. Look, we're just wanting to make it clear about what we're seeing in the practical use here. We welcome government's understanding and regulatory look at the whole industry as a whole. But we're concerned that we might be going a bit too early. Having travelled to Austin, Texas last year for the consensus and New York for the NFT function, this is a worldwide view. I mean, everyone is looking at how Australia is looking at digital assets. There's other people around the world. I recall talking to the token mapping people about what their intake is about what's happening around the world, and let's not try to reinvent this wheel. And the trouble is about trying to go too early, and this is a changing dynamic in Web3, and we're looking at, I mean, at the end of the day, does this at all protect revenue, this particular Schedule 2? Part 4A, I'm not seeing that this is a big issue out there in the practicalities. We advise on the whole industry since 2016 in Australia and internationally, and I'm not seeing that this is going to be a real threat to revenue. I mean, certainly we need understanding and taxation regulations. I just think, in concurring with what Gordon is talking about, let's see the Board of Taxation review go through, let's see token mapping go through, let's have holistic government on the digital asset framework so it intertwines with ASIC and tax regs. So I'm talking about a uniform. I'm just concerned that this doesn't have the relevance at this point in time.
Thank you. Gaydens, do you have an opening statement, or it's not required, but if you have one, go ahead.
Sure. So
Yeah.
I'm accompanying Gaydens today. I work for a digital currency exchange called SwiftX. We have about 700,000 customers, and we're one of the largest in Australia. I think as someone who works in the Australian crypto industry, I'm consistently faced with compelling reasons why we should get the regulatory settings right, by which I mean we should strive for this Goldilocks zone where our consumers are protected and our innovation remains world-class. I think there are many reasons for this, but here are two to start off our submission. First, the train of crypto adoption in Australia has to some extent already left the station. As Gordon mentioned, polling consistently shows that Australians are interested in owning crypto and participating in Web3. At least 10% already own it. ASIC tells us that rates of holding crypto are only behind rates of holding shares. Australia has one of the highest levels of crypto adoption in the developed world. And this will translate to use cases for Australian households and small businesses in payments, instant settlement, tokenization of assets. This in turn translates to real economic growth. So Accenture's report on digital assets in Australia, which was released late last year, found that the sector's contribution to GDP could reach 60 billion by 2030, with tax revenue in that year approaching 15 billion. And second, the journey to appropriate regulatory settings is to some extent a race with winners and losers. So there are reasons why Prime Minister Sunak wants the UK to be a crypto hub. The MAS wants the same for Singapore, and the EU wants that title for itself. Countries are realizing that because crypto is borderless, you can't cage it to force it to stay in the country. You can only encourage it with sensible regulation. So we might not be crypto native yet, but at this point we're all somewhat digital native, and Web3 is nothing less than the chance for the first time to take ownership of that digital ecosystem in which we inhabit. So we think anyway that an important discussion along the way is how crypto fits into our conception of property, and that's what the Gaydens submission is about. In this regard, I think Mr. Rob is well placed to assist.
Yeah, thank you, Senator. So, as mentioned before, I'm an academic, and we've been conducting some ongoing research into cryptocurrencies and crypto assets, specifically around the nature of them as property. And the current position in Australia seems to be that it's unclear as how it can be easily placed in existing positions such as a chosen action or chosen possession. This formed part of our submission around the absence of property being discussed, and this can then have ongoing flow-on effects, which Liam can add more to.
Thank you. Shane and Lachlan have each talked about the value of the Web3 economy to Australia and some of the legal challenges in terms of its classification as property. There is, through this committee's great work and through Senator Bragg's private senator's bill and through the token mapping exercise itself and further indications from the government around a licensing regime and a custody regime, a critical year ahead of us. It is a year in which we are macroeconomically competing with the UK, US, Singapore, Hong Kong, and regulation and the decision that you as policymakers make this year will be critical in terms of our future. Our point is a very narrow one, and that is a purely technical legal argument that to support your policy-making efforts this year, howsoever that they play out and whatsoever speeds they go, we need to determine that cryptocurrency has proprietary rights, failing which there will be a number of clever lawyers and barristers out there challenging the tax officer's ability to tax this asset, and whether they are right or wrong, those court actions will take years. There will also be private practice lawyers like myself who spend all day developing trust deeds, say, gee whiz, I know how to create a trust deed to hold property. I don't know how to create a trust deed, at least at this stage, to hold what I regard as data. We do not tax Google or Facebook or other social media companies based on the data that they hold on each of the individuals in this room. We do tax them on what is their property. We submit that that clarity should be put forth in Australia's legislation as it is moving towards in both Australia with Professor Green's leading work and indeed with the International Institute of Unification of Private Law's Digital Principles on Digital Assets and Private Laws paper in January 23 of this year, which expressly permitted the creation of a new category of asset for cryptocurrency. Thank you for the committee's work.
Thank you very much. I'll just start with some questions for you, Mr Hennessy, on Schedule 2 on this sort of fairly narrow measure. And then you've all raised much broader sort of issues as well about what kind of environment we need to create for the industry, which we'll get to, and I know Senator Bragg will also have questions on. Just in relation to the narrow issue of the tax treatment of crypto assets after the sort of one-off El Salvador event, Mr Hennessy, can you just confirm your understanding that the current measure does not change the tax treatment of digital currencies today in Australia?
Yes, that is my understanding, Senator Walsh. I think that the current tax treatment of digital currencies, from my reading and my understanding, and I should specify that I am not a tax lawyer but a humble financial services regulatory lawyer, is consistent. My concern is a broader jurisprudential one insofar as we are proceeding as if this asset is property, and we are doing so on the basis of our cousins' experience over in NZ, in the US and the UK. But our regulatory landscape and our legislative landscape is not quite theirs yet. So I wouldn't like to see us proceed down a common assumption based on the existing law and how the new legislation proposes to continue that, but it face court challenges.
Yeah, I think I understand the broad submission that people are making, which is about sort of sequencing, and that you all sort of welcome the broader work that is being done in the token mapping exercise and in the Board of Taxation's review in the tax treatment of digital assets. I guess, you know, my question back to you, Mr Hennessy, is that your general position is that, you know, this work needs to be done. Do you have an objection to fixing issues like this along the way?
Not
this
at all,
is
Senator.
effectively, fixing a tax treatment of digital assets in a very narrow way in relation to a very specific incident that occurred in El Salvador. Yeah.
Not at all, Senator Walsh. I think that the great work that this committee is doing should push forward in tandem with the other great work that Treasury is doing and other stakeholders, and that may be a point at where myself and Blockchain Australia differ. I think that we are, to adopt Shane's words, in an arms race in terms of crypto regulation. We have, if the EU can get 27 member states to agree on a framework for blockchain regulation, that's an impressive feat, and that will create a global hub for crypto assets, which we need to strive to keep up with. I think that the efforts that the policymakers that I'm addressing now and more broadly have is absolutely commendable, and I would say pedal to the metal. Our suggestion is a simple extra additional clause in perhaps this legislation or Senator Bragg's private senators' bills to designate, in a narrow sense, crypto as property, and we roll on with all of the other great things that we're thinking about in conjunction with the industry and advisors.
Right. So that sort of, you're seeking that sort of certainty in the regulatory environment to be able to build the industry ongoing.
Yes.
And again, this is just a very narrow, specific measure to provide certainty about tax treatment in response to a specific event. Just on that, because that's what is in front of us right now, do you agree that taxpayers do need that certainty about their digital currency assets, you know, for their tax returns?
I do, Senator Walsh. I think that a small amendment to this legislation to make it certain that cryptocurrency is property within this narrow context, because there will be other contexts in which digital currencies are used that may need a slightly tweaked definition, especially when it comes to licensing and custody. However, a narrow amendment to specify this is property, you need to pay your tax, and so that various barristers and private practice lawyers cannot look at this and think there may be a court case in this, would give certainty to consumers, it would give certainty to policymakers, and indeed to market participants like SwiftX.
So you'd like the broader reviews that are underway to also designate crypto as a property asset? Is that
I would
your
like them to consider that in the context of their particular objectives, certainly in the objectives of this legislation we're speaking about. Crypto should be designated as property so that there are no controversies from a taxation perspective. When we come to licensing and custody, the issue should be revisited. If the designation of crypto and digital assets as property, the definition that potentially this committee comes up with is fit for purpose for those other pieces of legislation, they can either be adopted or amended as needed. Yes, I think that it should be taken forward here, and I don't think that it needs to slow down any policy-making innovations in other areas.
Okay, thank you. I know Senator Bragg will have a lot of questions for all of you, so I'll turn to you, or some questions. I'll turn to you, Senator Bragg.
Yeah, thanks for that. Look, I think you've probably covered most of the content. So do you want this amendment to pass?
Sorry, Senator, who are you addressing in relation to that? Blockchain Australia are just making some observations on our recommendation. We just think that it's a touch early at the moment. We think that we'd like the Board of Taxation to complete their review and the token mapping. With my learned colleague Liam, I understand he wants certainty, but this is a world decision on what's happening in the Web3 industry. We're constantly, I'm involved with speaking to the ATO constantly and clients at the coalface, and from an understanding of taxation, there's further work to be done, and there's definitions in Treasury and other bodies and ASIC, and I think there has to be a consistency to get to that destination, and I think it's a tad early. So I think you need to think this through, because Web3 is moving so fast, and I'm not sure if anyone has been around the world here and had a look at what's happening in all the other countries, which is particularly important for our decision making here, because this is global, what effect it has, and how we can be a market leader in Australia and a destination. I was in Austrade in New York, and I was at a dinner with Nick Greiner, and one of the things I said that's a fearful issue here for Australia is, and I've had evidence of that, of clients moving up and leaving Australia because of the taxation regime or the certainty or the difficulty. A client has gone to Germany, a $250 million business. We're having people globally.
And do you think this will send the right message or the wrong message?
I can't see I think it's way too early for, I think it's a wrong message, Senator. I think it's a bit too early at the moment. And I think with some real learned decision.
Is that because it's been cherry picked or?
Cherry picked, absolutely. And I think the issue is, do we have statistics to show us the threat to revenue? I think that's one of the major costs in taxation. Part 4A is the ATO come at a diagnostic tool that says that this is a threat to revenue. I've not seen it on the practical sense at the coalface. I don't know how many people here are at the coalface, but I've not seen that. I think there's so much more work to do to assist the industry, and I think you've got to be talking to people that are actually dealing with the clients out there as a representative. And I understand all our learning colleagues here want the same thing, and that is for certainty.
Okay, thank you. That's very helpful. And do you think that we are maintaining the momentum we had on digital assets in the last parliament? Are we still on the same trajectory? Are we still moving quickly?
No, we think, Senator, that we're hoping for the new government to have some strong understanding and some go-to as industry body representatives to be able to have a seat at the table, to work for the greater good, and have a strong working party which is bipartisan. I mean, this is for everyone. This is not just Labor or Liberal. We want the greater good of the country. We want Australia to be a destination, a global destination, and be one of the front runners in this industry. And I look at New York, I look at Austin, Texas, I'm looking at Germany, UK, Portugal. There's plenty of things going on in there, and we can take a lot from what the world is doing.
But do you think we're heading in the right direction? Are we still keeping up a good pace?
I think we're vacillating. I think we're in a holding pattern at the moment, and there's uncertainty. And so I've had exchanges that have contacted me and are concerned about where Australian regulatory is going.
Okay, thank you very much. Thank you, Chair.
Thank you very much, Senator Bragg. That concludes the questions that the committee has for you today, so we very much appreciate your appearance as witnesses today. The committee has agreed that responses to any questions on notice should be provided by close of business Thursday, the 23rd of February. Thank you again. We wish you all the best.
Thank you, Senator.
The committee will take a short suspension. Let's see. I now welcome in-person representatives from the Board of Taxation and Treasury. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today? And we might go this way, Mr Klein, starting with you.
Sure. Thank you, Senator Walsh. Anthony Klein, I'm board member and reviewer of the Board of Taxation.
Senator Walsh, I'm Roshane Garnon, I'm Chair of the Board of Taxation.
Hello, I'm Susan Baldertude. I'm the Acting Assistant Secretary at Treasury in Corporations and International Tax Division, so we were responsible for the policy elements of the bill.
Good morning, Greg Wood. I'm the Director of the Corporate Tax Policy Unit in Corporate and International Tax Division in Treasury.
Morning, Nii Liu, Assistant Secretary, Financial System Division, Treasury.
Great. Do either of you have any opening statements, or should we just proceed to questions?
I've got some opening statements.
That would be great, thank you.
So, Senators, thank you very much for the opportunity to appear today. I want to give you a little bit of background on the Board of Taxation, which is a non-statutory advisory body that provides the government with real-time advice on tax system issues by contributing a business and tax community perspective to improving the design and operation of taxation laws. The members of the board are part-time and are appointed by the Treasurer for a 3-year term, and the appointment may be renewed for a further term. In determining the mix of the board, business experience, skill set, gender and geographic diversity are considered so that the board can bring a broad range of perspectives to the table. The board is unique in that it brings together 7 private sector business leaders and tax professionals, with 3 ex officio members, including the Commissioner of Tax, the Secretary of the Treasury, and the First Parliamentary Counsel, to advise the Treasurer and Assistant Treasurer on the tax system and how it can be improved. The board is supported by a secretariat provided by the Treasury. The Secretariat consists of Treasury staff, secondees from the ATO and other government agencies, as well as the private sector. The board undertakes in-depth reviews as and when requested by government and provides input on tax policy and law design matters in real time as decisions are being made. During the course of the board's work, it works closely with business and the community. The contributions of stakeholders inform the board's advice to the government. It is important to note that the Board of Taxation is not responsible for the administration nor the implementation of government policies and programs, whether generally or in the area of taxation. These are matters for the Department of the Treasury and the Australian Taxation Office. Currently, the board is undertaking a review of the tax treatment of digital assets and transactions in Australia. Appearing with me today is Anthony Klein, who is currently leading this review with fellow board member Tanya Titman. They are assisted by a working group comprising members of the tax profession, academia, and representatives of the ATO and Treasury, and officers from the board secretariat, which is based in the Treasury. The review was announced by the former Treasurer on the 8th of December 2021 as part of a broader response to a review on Australia's payment system and the regulation of digital assets. The terms of reference were issued by the former government in March 2022 and were confirmed by the current government in August 2022. The terms of reference have asked the board to consider the current Australian taxation treatment of digital assets and transactions and emerging tax policy issues. Consider the awareness of the taxation treatment by both retail and wholesale investors and those transacting in digital assets as part of their business. Consider the characteristics and features of digital assets and transactions in the market, including the rapid evolution of technology supporting the broader digital asset ecosystem. Analyse the taxation of digital assets and transactions in comparative jurisdictions and consider how international experience may inform the taxation of digital assets and transactions in Australia. And finally, consider whether or not any changes to Australia's taxation laws and/or their administration are warranted in the context of digital assets and transactions for both retail and wholesale investors. The review has raised some complex legal and tax policy issues and is ongoing. The board is considering these complex issues raised in written submissions and public consultations, but has not yet formed any views and recommendations. Also, the board is currently consulting with revenue authorities in the United States, United Kingdom, Canada, Singapore and New Zealand, and we are due to report to government by the 30th of September 2023. The board's review is not impacted by the legislative amendment in Schedule 2 to the Treasury Laws Amendment Bill being considered today. The amendment is restricted to clarifying the current tax treatment of Bitcoin and other similar digital currencies, while the board's review considers the treatment of digital assets and transactions more broadly. Thank you for the opportunity of making this statement.
Thank you very much. So I note, Mrs. Garnon, in your opening statement that you made it clear that you're not responsible for government programs. You are conducting this broader review that's, relevant to the issue of digital currencies, digital assets. You described that you're conducting some public consultations as part of that review. Is that right? And can you tell us a little bit more about what opportunities industry has to participate?
Absolutely. And if I talk about our reviews generally, and then what I'll do is I'll pass to my colleague who'll talk about these specific ones. When we undertake a review, once the terms of reference are laid out, we then produce a consultation document, not dissimilar in form to what Treasury typically do, and put that out there. So through our networks, on our website, LinkedIn, etc., asking for responses. We will typically get responses. We'll have people who want to come along to the consultations, and then we will also receive written submissions. From that work, we then compile an issues list, and then we have a working group of a range of people with different expertise who will work with us, including Treasury and the ATO, to distill the issues down and then produce our recommendations for government. Now, Anthony, I'll let you comment on the specifics here.
Thanks, Roisin. Yes, Senator Walsh, the consultation process has been very broad, and we've been really pleasantly surprised, I guess, by the amount of engagement by the community and the participants. We've had 9 verbal, whether they be face-to-face, in-person or virtual sessions, which have involved 45 different stakeholder groups. In addition to that, we've received written submissions from 41 different parties. So that amounts to hundreds of pages of written content as well. In terms of the nature of participants through those processes, it's been very broad as well. We've had participation from industry participants, whether they be wholesale or retail investors, exchanges and other intermediaries participating in the crypto asset space, professionals including tax advisors, and even founders of some of the software products that are being developed to deal with this matter.
Okay. And are you able, within the scope of what you do, to give us a general indication of your insights at this stage about how important it is for Australia to have certainty and clarity in our regulatory environment for the treatment of digital assets? How much is industry looking for that? How important is it that we maintain Australia's reputation as a good place to invest?
Yes, Senator Walsh, it's a great question, and it's been pretty much resounding, the importance of certainty and, wherever possible, simplicity in terms of what the law looks like. That message has come to us from a broad range of stakeholders, not only the end taxpayers who are, whether they be trading or transacting with crypto assets, or whether they be the advisors who are supporting them through the compliance process. We've heard very loud and clear that having certainty is one of the most paramount needs of the community at the moment.
And while you're not responsible, as you said in your opening statement, for government program or government policy and can't necessarily speak to that, do you have a view for the hearing that we're in today about this narrow measure of Schedule 2 responding to the specific issue that was created with the decision of the Salvadoran government? Do you have any views to share with us about, whether it provides better certainty for investors and their advisors just on the narrow issue that it seeks to solve?
Absolutely, Senator. So with the El Salvadorian announcement, what that has done is it's opened up the possibility for different approaches to be taken by taxpayers. And so the question that I think our colleagues are trying to deal with is horizontal equity within the tax system. And so what we try and do when we're doing our work is to think about how we can make sure that there is simplicity, that there's clarity, but that you do get consistency of treatment. What this announcement does and legislation is to take us back to the status quo before that announcement was made, and so it's clarifying. And the real driver, in my personal opinion, is that it is helping the ATO administer the system.
Great, thank you. I'll just ask some questions of Treasury now in relation to Schedule 2. Are you able to give a bit more of an example of the problems that the lack of clarity that we currently have around the treatment of digital currencies it could cause a person or a business without proceeding to this amendment? I'm not sure who I'm asking.
Yes, to Susan Bultitude.
Yeah.
Yes. So as in the months following the El Salvadorian announcement, and as tax time for that financial year approached, the ATO had many representations from taxpayers and from tax advisors through their various stakeholder engagement arrangements that there was this uncertainty and that taxpayers didn't know how they should be treating their Bitcoin transactions in their tax return for that financial year and indeed future financial years. So there are, broadly speaking, two possible interpretations. So one is the one that had existed before the El Salvadorian announcement, where the tax treatment for Bitcoin, it does depend on the individual circumstances of the taxpayer and the transactions, consistent with ordinary tax principles that apply to other investments, including traditional investments. Or another interpretation being that now that El Salvador had Bitcoin as its official currency, that now Bitcoin should be treated as a foreign currency. So foreign currency has a particular tax regime where it is treated on what we call the revenue account. So it is treated where the gains on foreign exchange made on foreign currency is in your assessable income, and any foreign exchange losses are treated as deducted against your assessable income. So two potentially quite different tax treatments, and the taxpayers didn't know how they should be treating it. So from there, you end up with some other issues. So you might have two different taxpayers who are honestly doing their best to comply with the law, might have two different interpretations. And that's the horizontal inequity that Mrs. Gunnan was referring to. So you might have different outcomes for people in similar circumstances. You might also have people who perhaps are wanting to minimise their tax payments to perhaps choose the interpretation that best suits them at that particular time, and that, of course, would have a revenue cost. Now, in all of this is the ATO. Where there is uncertainty in the law, that makes it more difficult for the ATO to provide guidance because there perhaps is not one clear interpretation. So there's implications for the extent to which the ATO can assist taxpayers to understand how the law should be applied and how the ATO will administer it.
Great, thank you. Are you able to explain why it's useful for Schedule 2 to pass now, before the token mapping review is complete, and then the work that comes out of the token mapping review is then considered more fully?
Yes, so it really follows on from this uncertainty that having this law passed now means there's certainty for taxpayers and for the ATO about how the law applies, because the uncertainty has existed from the 2021-22 financial year, that means for all these financial years in the interim until the token mapping exercise and the Board of Tax Review have been completed and the government has considered its response, we can have that certainty in the interim. passing this law now does not in any way impede on the terms of reference of those reviews or the government's ability and Parliament's ability to make further changes down the track as appropriate and as, of course, this rapidly evolving area continues to develop.
Okay, thank you. Senator Bragg, do you have questions?
I think just very briefly, so when is the report going to be finished? The Board of Tax report?
Senator, the Board of Tax report is due to be handed to government on the 30th of September 2023.
And is that the same timetable that was set when this inquiry was established, or has it changed?
It has changed, Senator.
Okay, how much time has been lost?
Effectively, it's been extended by 9 months.
So we'll be 9 months behind where we would have been under the initial timetable.
Correct.
Okay. Now, obviously, I've had very productive meetings with the Board of Tax, and I know that you're doing a lot of industry engagement. Obviously, you'd be aware of the statements that have been made today from industry, suggesting that your report should come first. Is that consistent with the advice you hear across the board that people would like to see your report concluded before tax changes are made?
Senator, why don't I ask the head of the working group to answer that for you?
Thanks.
Yeah, Senator Bragg, we've certainly heard feedback through the consultation process that stakeholders would like the law to be as settled as possible across the various issues that exist. The matter that we're talking about today is only one of those matters. I think, though, it's fair to say that the passage of this legislation would not impede our work one way or the other.
No. But obviously you're aware of what Blockchain Australia has told this committee, that this is being cherry-picked.
We've had consultation, Senator Bragg, with a number of bodies, including Blockchain Australia, and they've made those points to us, yes.
Yeah, okay. So, yeah, sure. But what signal is it sending the market that this is being pulled out of nowhere ahead of the rest of the inquiry?
I think that would have to be a matter for Treasury to answer, Senator.
Senator, yes, we did receive a number of submissions to our bill that the bill should perhaps wait until the broader issues that are being examined on the regulatory front and the taxation front are complete. In response to those submissions, we did add into the explanatory memorandum a reference to both of those processes, so that it is very clear that this piece of legislation is being put in to maintain the status quo while those other processes are underway. So we've put that signal in the explanatory memorandum, consistent with, I think, the concerns that were raised with us in the consultation.
So what's the outworking of all this work? Is it going to be a tax bill in time that deals with all the digital asset issues?
Well, that's going to be a matter for government, Senator.
And do you think that's achievable in this parliament?
Senator, that's going to be a matter for government and the government's priorities going forward in this term of parliament.
That's a very good answer. Very good answer. That's an answer that should be displayed as how to present Senate estimates. But I understand that. But I guess my point I'm trying to get to is, the token mapping piece is out there now. Now, when is that going to conclude?
Nilu, Assistant Secretary, Financial System Division. The work is ongoing. It will form a key input into the work on licensing and custody, which the government's committed to produce by the middle of this year.
Okay, so when do you think we'll have legislation on licensing of gatekeepers?
I think, consistent with my answer at Senate estimates, that is a matter for government when they would decide to legislate.
Yeah, but didn't you say it's an estimate that there'll be another consultation paper on this?
Yeah, there'll be a consultation in the middle of this year on licensing and custody.
Yeah, which Treasury's already done.
No, we had the useful March paper that was done in 2022. We've looked at the submissions. We're taking stock of all the developments since, and we'll be putting out a subsequent paper in the middle of this year.
Yeah. Yeah, so you're doing a second paper on licensing of crypto markets later this year. So, so that will be the end of 2023, and then we'll get to 2024. We might get draft legislation in that year. And do you think the Board of Tax issues will be dealt with as part of a package, or do you see those as separate pieces?
Yeah, I speak this. The two processes are informing each other, and we're working very closely with each other. There are members of Treasury's Markets Group who are on the Board of Tax Working Group as part of Treasury representatives, as well as the tax area. No decision has been made on how on any particular response to the issues that are being considered, because both processes are still ongoing, and how those may be packaged. But the two will most definitely be informing each other and ensuring that they are complementary and consistent. One message that we have heard consistently from stakeholders is to make sure wherever possible that the regulatory frameworks and the taxation frameworks are consistent, that if we are to use definitions, for instance, that the definitions are consistent, so that we can have as much clarity, simplicity for stakeholders, taxpayers as possible, and also to minimise compliance burdens and administrative costs.
Yeah, but that's good. But I mean, but the Treasury's going to release another consultation paper on crypto markets that it's already done 18 months after the first one. And by the time you finish so when is your Board of Tax report finishing?
The 30th of September 2023.
September 23. So you're going to have two reports. Well, you'll have a Board of Tax report at the end of 2023. You'll have another Treasury consult paper out. By the time those conclude, we'll be well into 2024. So, I mean, we're not looking at, there's not going to be any substantial improvements to the law in Australia this year, is there?
Senator, as I said before, no decision has been made about content of any legislation, timing of any legislation while these processes are still underway. And that will be a matter for the Board of Tax and Treasury's reports and our advice to government, and the government, obviously the priorities of the government and the decisions of the government.
No, I understand that, but I think my tumbleweed there that appeared on the screen was very telling. So okay, so there'll be no major changes this year. Maybe something next year. Okay, well, thank you for clarifying that.
Thank you, Senator Bragg. I just missed one question on Schedule 2, which was just around the consultation details for this specific measure. So there was a Treasury consultation in September. Do you have any details for the committee on that?
Yes, so the consultation, the explanatory memorandum and the draft bill were put out on the Treasury website on the 6th of September. The consultation closed on the 30th of September. We received 16 submissions, of which 2 were confidential. Around half of them were from individuals and the other half from organisations. So those included the tax advising or accounting bodies, legal firms, academics and the cryptocurrency industry. There were a range of matters that were canvassed in the bill. A lot of those matters did not relate to this particular sort of more narrow, as you described it, policy, but some of the broader issues that are being considered by the Board of Tax and under our review of regulation. So those submissions have been passed on to our colleagues here to inform those processes. The ones that spoke about the bill, in general, were supportive of the bill, welcomed the clarity that was being provided and the position being taken, supported the regulation-making power, and supported the limited retrospectivity of the measure to provide that clarity all the way through from the year in which the El Salvadorian announcement was made through to the present and going forward.
Thank you. We're going to schedule one after a short break. Are you able to answer questions about the digital games tax offset?
The people here were not involved in the preparation of that measure. That's actually another part of Treasury, so I'm not sort of in a position to answer any questions on that bill, or that schedule, sorry.
That's okay. Okay. I think that concludes the questions that we have for you. Thank you all for appearing as witnesses for us today. We really appreciate your evidence, and you go with our thanks. The committee will now suspend until 10:45. We've got our online people. The committee will resume, and I now welcome in-person representatives from the Interactive Games and Entertainment Association, and by video conference representatives from the Screen Producers Australia. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your name and the capacity in which you appear today? And we might start with you, Mr. Au.
Good morning,
You're
Chair.
in the room.
I'm Ben Au, Director of Policy and Government Affairs at the Interactive Games and Entertainment Association, which you can just call IGEA.
Thank you, Mr. Au. And the Screen Producers?
Hello there, my name's Matthew Diener. I'm the CEO of Screen Producers Australia. Also joining me is Nathan Anderson. Do you want to, Nathan, you go ahead.
Yeah, hi there. My name's Nathan Anderson. I'm a producer and council member at SPA.
Great. Thank you very much, Mr. Diener and Mr. Anderson as well. Does either IGEA or Screen Producers have an opening statement? Do you?
I do.
Mr. Au? Okay. Please proceed.
Thank you. Good morning, Chair and the Secretariat. First, I'd like to thank yourself and the committee for the opportunity to speak before this inquiry. The Interactive Games and Entertainment Association is the peak body representing the video games industry in Australia. Our interest this morning is in Schedule 1 of the bill, which will introduce the Digital Games Tax Offset, or the DGTO, the first ever tax incentive to promote the development of video games in Australia. This is a landmark policy that we have advocated strongly for over many years. The DGTO is widely supported across Parliament and represents genuine bipartisanship. We are talking about a policy that was originally proposed by the previous government, introduced into Parliament by the current government, and for many years prior had been a recommendation of practically every parliamentary committee that turned its mind to it. To all the policymakers who have worked on driving this forward, we say thank you. The DGTO provides a 30% incentive for eligible game development businesses that spend a minimum of $500,000 to support their projects, including both brand new projects and the ongoing development of existing video games. Schedule 1 clearly sets out the parameters of the DGTO, how it will work, what is eligible and what is not eligible. And various integrity measures have been put in place to ensure that the policy is targeted and sustainable. While there are many similarities between the DGTO and the existing film and TV screen offsets, the work on the design of the DGTO, which has spanned both sides of last year's election, reflects thoughtful consideration of how video game development works in particular and significant consultation with our industry. We appreciate both the Office for the Arts and the Treasury for all of their work in this regard. While there are some differences between the DGTO as outlined in Schedule 1 and the model that we had suggested, these Differences are mainly minor, and we understand the policy rationale for these areas of difference. In its current form, the DGTO under Schedule 1 is highly effective policy, and as an industry, we are really just ready to hit the ground running. For this reason, as we have outlined in our written submission, we are in complete support of Schedule 1 of the bill, and it is our hope that it is swiftly passed in the Senate. The games industry and the game development community has been eagerly awaiting the DGTO for a long time, and to say that it will be massive for us is an understatement. It is not only the most revolutionary reform that has affected our sector, but we believe it is also the most exciting arts policy reform that we have seen in a long time, and one of the most transformational policies for any emerging industry that we have seen. And while you could make the case for the DGTO on cultural reasons alone, given the impact it will have on expanding Australian stories, settings, expressions and voices online, it is economic policy, and its economic benefits are the most compelling. Video games is massive. Globally, it is a $250 billion industry, economically more than twice the size of the global film and music sectors combined, and it only continues to grow. The DGTO will allow existing Australian game development studios to expand, grow their teams and increase their production slate. It will lead to new studios being formed all around the country, and it will attract vast foreign investment from the global games industry, including through their investment into existing studios and the establishment of brand new ones, including blockbuster AAA studios, as they are called in the industry. All of this will lead to a boom in Australian-made games, an incredibly high-value, weightless product that is already one of the country's most valuable and significant creative exports. It will also lead to a boom of highly skilled, incredibly versatile and uniquely creative technology jobs with value well beyond our sector. And through the allure of a vibrant and shiny game development industry, the DGTO will attract a new generation of Australian kids into STEM and other future-focused fields of study. Our industry is so ready for the DGTO that even the anticipation of this policy, which was first announced last year, has already started to trigger some of these benefits. Much more awaits in the years to come. This is why our most significant priority now is the implementation of the DGTO, and we respectfully ask that the committee that recommend that the bill be passed in the Senate. And should the bill as a whole need to be delayed for reasons with other schedules, we ask that Schedule 1 be separately passed, should that be possible. Thank you very much.
Thank you very much, Mr. Au. Mr. Diener, did you have a short opening statement to make?
Yes, thank you, Chair, and thank you, Senators. Look, I'll introduce ourselves, but we largely also agree with the IGAA as well. Screen Producers Australia, we represent small and large enterprises across all forms of screen content, so we're the peak industry trade body from the 600 or so screen businesses, and a number of these businesses are game developers or have mixed models in their production, so they do film, television and games. And we've long championed the game sector as part of the overall ecology and the need for the Australian government to support the industry in this way. We are aligned with IGAA. We think the new incentive will provide much needed support. It will do a lot of things for us on the international stage, incentivise economic activity, job creation and business success. It also will bring us into alignment with other support measures, and that's only a good thing. I think in our submission, we raised a number of minor issues with drafting, as well as recommended a review process taking place within 2 to 3 years of operation, so that just in case that there were any unintended consequences or problems for the sector, and to provide the opportunity to address these without delay. However, overall, we urge the swift passage of these measures in the legislation. Our members similarly have been anticipating and working towards working with these measures since they were announced in the 2021 budget. So we want to avoid any sort of further delay here and get people working on things and the expansion that has already been outlined. We also foresee. So thank you very much.
Thank you very much, Mr. Diener and Mr. Au. I will just quickly say that in my few years on this committee, I don't think I've ever heard such positive opening statements, including the fact that the reform's been worked on for a long time and is genuinely bipartisan. And words like massive and revolutionary, exciting and transformational and vibrant and shiny are very nice words to hear on what is usually a fairly dry Senate Economics Legislation Committee. So we thank you.
We're part of the entertainment industry. We're here to help.
You are all delivering. Thank you. I'll just ask a couple of quick questions. And because your opening statements have been and your submissions have been very helpful. The industry is growing, as you've both said, and growing and exciting, but what are the current challenges in attracting and retaining technical and creative staff here in Australia, and how might this measure help boost the workforce here in Australia and their skills? I'll just start with you, Mr. Au.
Yeah, absolutely. I think what we've seen over the last 10 to 20 years is a number of highly advanced economies all around the world recognising the potential of building vibrant video game development industries, in their countries, and through kind of a range of policies that they've kind of implemented, particularly in the UK and in Canada, with incentives similar to what is outlined in Schedule 1 of the bill here with the DGTO. They have been able to build really highly skilled and technical workforces, and including many Australians who have moved overseas to work in those industries. And that's one of the reasons why, even kind of adjusting for kind of population, the game development industries in Canada and the UK in particular, they're many times the scale of ours. So with the existing community here, we have, Australia has in the last few years developed a really strong reputation globally for talent and creativity. But as the sector is starting to grow, it is getting more challenging to kind of retain skilled workers in Australia, and also to make sure that there is enough studios here so that students and kind of emerging developers are encouraged and have the confidence to know that they, are able to kind of work here. And for this reason, what the DGTO will do is provide a way for the industry to really be able to ramp up their ambition and their production slate, and to know that they're able to kind of achieve their full potential. And that is why so many members of ours, when they've spoken to us about what the DGTO, in anticipation of the DGTO, they are already starting to build their teams. They're already starting to develop kind of networks in universities. They're already kind of offering kind of positions wherever they can find the talent. And the only thing that the DGTO really will do is kind of increase the budget of games and increase the ability for these studios to grow and take on more projects and to expand the budgets of existing projects.
Great. And Mr. Diener, did you have anything to add to that in terms of how this might help boost our technical and creative, workforce and the jobs in the sector here in Australia? And also, having heard Mr. Au's answer, can I just sort of add a second part to that question, which is how will the measure encourage investment in the sector here in what is a very globally competitive environment?
Thank you very much, Senator. And Chair, I also would like to use the opportunity to throw to Nathan as part of this response, because he is a practitioner in the field employing people. But let me just start by saying that first of all, these measures are really important signals from government to say to a sector that creative industries are valuable and we're investing with private industry and private sector together to build. And we are talking about industries that are kind of at risk at times. They're sometimes gig-based. There can be a reasonable amount of upfront investment needed. So when government steps in to do the type of thing that this measure introduces, it gives business a lot of confidence to, first of all, employ a lot of people and know that the government is partnering with them, and to do its own level of investment. And that comes from both domestic resources and global resources. So all of a sudden you get business confidence up. You get business confidence up equals employment confidence, so that people are signalled that there is a role for them, and that when they're going through education processes, they know that this is an industry that, instead of another industry which has been, resourced in different ways, this is actually a pathway for them for a career. So that's, I think, a big shift of both optics, but also practical changes that happen across what is, it can be at times risky industries in terms of this sort of work. The other 2 points is that, like the IGA have said, this is about signalling a return to home. So we have a lot of talent overseas that hasn't had a home in Australia because we haven't had the capacity or the intent or the build of this sort of scale. And we are really, pleased to be bringing people home. The third thing that this measure does is, if it's doing what it's doing, we should enable intellectual property to be built in Australia, which gives stability to SMEs to be able to continue to produce and create and nurture the next generations of creators. So all of these are really sensible sort of measures for creating stability in a sector that otherwise doesn't have a lot of stability. And the fact that it's an ongoing kind of commitment from government sends a really big message, as opposed to a sort of a one-off grant scheme that can be done through other types of programs. So that's my sort of overview points around this. But Nathan, do you like to jump in and add a few points?
Yeah, thanks, Matt. Yeah, so just as a matter of context, I run a virtual reality studio called New Canvas. We're based in the Northern Rivers of New South Wales. So typically we create VR games and what we call immersive media content, which is essentially narrative-based immersive media. So specifically, I guess, the bill, and thanks for the opportunity to be part of this today. I'm tremendously excited, and from all my colleagues and peers we talk to, there's unanimous support for this. But sort of two, I guess, facets to expand upon. The one that Matt just touched on then is that when we're pitching projects to international partners, whether that's Meta or other technology partners globally, knowing that we can have a component of that budget secured and through eligible expenditure, it gives us a point of competitiveness that we didn't have before, and that flow-on benefit goes to IP ownership and creative control. And those two things are obviously key to sustainable business in the long term. And moreover, specifically for my sort of in my business and where I'm working as well regionally, I think this industry, potentially more than other production sectors, is geared towards remote and regional work. So this gives us flow-on benefits from employment and individual business components as well. So I think there's a lot of aspects to the benefit from this bill.
Thank you very much, Mr. Anderson, and it's really great to have somebody who's working in the industry come and give evidence to a Senate committee from the coalface. It's really appreciated. Thank you. I'll go to one of the issues that is attracting attention on the bill, which is the treatment of gambling-like practices in games in this schedule. And the issue of loot boxes. So I'll just start with you, Mr. Au. What is your view on the eligibility criteria that's set out in the legislation, excluding games that are substantially comprised of gambling or gambling-like practices?
Thank you for the question. This is an area in which I would say we've worked closely throughout the design of the DGTO with the government on, and we've been consulted and we've been able to provide our views. I think that what the bill provides is significant signalling on the types of games that should and should not be eligible for the DGTO. It is clear in terms of how it's worded. Additional commentary is provided in the EM, which is very helpful. But most importantly, we know that it provides a way for, I believe it's the Minister, to set rules around this topic so that if in the future there are issues relating to video games with, as the bill kind of uses the wording of gambling or gambling-like elements, then that flexibility is provided to ensure that they can be addressed. We are happy with the wording in the bill. We think that it's an approach that is useful. And signals the government's policy intent, but what it doesn't do is that it doesn't set a blanket rule that would impact on games that the bill and legislators would not have intended to be covered by the terminology. And once again, they can be addressed in future if unexpected circumstances arise.
Okay. Thank you. So, in relation to loot boxes, is it the case that some loot box features in games could comprise gambling-like practices, but other loot boxes may not? And what would the implications be of amending the legislation to exclude application to development of any game featuring any loot boxes?
Yeah, sure. Just on the topic of loot boxes, I will say that the topic was subject of a specific inquiry, I believe in 2018, by a Senate committee, which concluded that this mechanic in video games, there was no evidence for the need for further regulation at this time. And I will also say that it is also currently subject to an existing House of Representatives committee inquiry as a part of the online gambling inquiry. So that is still a process that's running and will run for a period of time. I think loot boxes is a complex topic. As a mechanic, as I mentioned earlier, it comprises a range of features in games. Some of these features have been around in games for a very long time, over a decade. Others simply mimic features that you would find outside of the video game space, for example, in packs of trading cards. But there are examples of loot boxes that have been subject of criticism, and some of that criticism, is valid and understandable. I think the danger of including something in this legislation that specifically excludes a feature that is that terminology that encompasses a wide range of features and aspects runs the risk of excluding from the eligibility of the DGTO certain features in a game, in an Australian-made game, that has never been the subject of concern, and they would, through a blanket rule in this bill, be excluded from implementing it in their game. And this could be, just to give you an example that might be helpful for this inquiry, it might include a game where a small amount of an in-game currency is used to open a mystery box that might provide a randomised character that could be used in the game, and the consideration for the purchase of that kind of small mystery box might be very small, and intent of that was simply to provide a kind of a chance-based element to add to the game.
Okay, thank you. Mr. Dina or Mr. Anderson, just reflecting on my question and Mr. Au's detailed response there as well. What's your view on whether the exclusions should be amended to exclude any game featuring any loot boxes?
Look, I think I'm in agreement with the IGAA that to kind of go in with a ban on all loot boxes in some way would be perhaps a little bit too far, when what we're trying to do is we're trying to ban gambling, I think, through this process, right? That's the intent. And I'm not, I defer to Nathan if he has a sort of more detailed analysis of this. The reason we've thought that the legislation should be reviewed after 2 to 3 years is to kind of in a broad measure look at a lot of things if everything's working as intended, but this would be one of those areas where if there was some greyness that had been created because it wasn't explicitly in the bill and it had only been in the EM, then it would be something that would be addressed at that point. But my inclination is that if there's a bit of flexibility, knowing that the intent is to rule out any kind of support for gambling per se, then that would be the right way to go at this point. Nathan, do you want to add to that?
Nothing too much to add to that, I guess. Yeah, just echoing that point that obviously excluding, gambling products is certainly, what we in the industry would consider to be the right approach. But, I think the IGEA's comments around the complexity of the topic is correct. And, what we'd want to avoid is any, stifling of innovation in this sector that might be through some legislation that may not be, accurately outlined as well. So again, support the component for review and also just the additional submissions that SPA have already made on this topic as well.
Okay, thank you. And just a final question from me, Mr. Au. Given the issues around the harms associated with gambling, what is your industry doing to mitigate the harms that may be associated with gambling-related mechanisms attached to loot boxes?
Sure. I will just say at the outset, our membership does not include members that make simulated social casino style games. So I'll exclude that from the topic here. On the topic of loot boxes, first of all, the industry's response has been significant investment in controls. So these are parental and family and carer controls at both the game level and also at the device level. And the intention of these controls is to ensure that individuals, and in particular parents and carers, have as much agency and control to make choices and make informed choices as to whether or not in-game purchases is allowed. Another initiative globally that the industry has undertaken and committed to over the last couple of years in particular is an investment in ensuring that there is transparency about the fact that loot boxes and in-game purchases are included in a game, so that prior to the purchase of a game, that this information is readily available. And another initiative that has been kind of undertaken across all of the kind of the major video game companies, and a commitment that's been made at the global level and in Australia as well, has been transparency in terms of the probability or the chance of receiving various items in in a container, in a loot box. So how this would work is that video games would need to make available what the odds are of receiving certain items, so that the relative kind of rarity of items contained in a loot box container are as transparent as possible. And these are measures that really are just faceted, but also in recognition that we are always kind of monitoring community concerns, feedback from players, as well as the research as it is being made, so that industry can continue to improve and to make sure that these games are offered with the the safety and care and trust of the players who enjoy them.
Okay, thank you very much, Mr. Au. Thank you also to Mr. Diener and Mr. Anderson. That concludes the questions that the committee has for you today. The committee has agreed that responses to questions on notice should be provided by close of business Thursday, 23 February. Again, the committee extends our thanks to you for coming and giving us your evidence today. We very much appreciate it. And for the representatives of the screen producers, we'd ask that you disconnect, and if you'd like to watch along, to do that through the live stream on the Parliament's website. Thanks again to all of you.
Thank you, Chair.
I now welcome by video conference representatives from the Defence Force Welfare Association. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today? Can you hear us okay, Ms Bowden?
Yeah, yes, I can. Sorry. Kate Bowden here. I'm here as the National Treasurer of Defence Force Welfare Association.
Great. And we have other witnesses there as well? Yep.
Yes, we do. John, we can't hear you.
My name is John Lewis. I'm the Queensland President of the Defence Force Welfare Association.
Thank you.
And Del? We don't have any sound.
Hello, I'm Del Gaudry. I'm the National President of the Defence Force Welfare Association.
Great, thank you very much. We can hear you all, so we're good to go. Thank you. Ms Bowden, did you have an opening statement that you wish to give?
So, yes, I do. Thank you. Senators, ladies and gentlemen, my name is Kate Bowden and I'm here today with my colleagues representing the Defence Force Welfare Association, DFWA. DFWA is an independent voice for Australian Defence Force members, veterans and their families, and we advocate to government on matters affecting the welfare of this group of Australians, with a particular interest in government policy. DFWA's comments today specifically address Schedule 9 of the Treasury Law Amendments 2022 Measures Number 4, Bill of 2022. These amendments are trying to address a complex matter of superannuation and taxation law, and we welcome the opportunity to be part of this discussion. DFWA's position on Schedule 9 is endorsed by the Return Services League Australia, RSL, the Australian Peacekeeper and Peacemakers Veterans Association, APPVA, and the Alliance of Defence Service Organisations, ADSO. While DFWA supports some aspects of Schedule 9, we also believe that the amendments as drafted will further embed inequity in the tax treatment of invalidity benefits for veterans. We are happy to provide examples of how a veteran's tax treatment varies depending upon their superannuation scheme or the start date of their invalidity payments. We believe that all veterans should be getting the same tax treatment of their invalidity superannuation payments. There are 3 areas of Schedule 9 which are supported by DFWA. Firstly, Schedule 9 removes any uncertainty and delayed action as a result of the Commissioner of Taxation versus Douglas decision of 2020. The Douglas decision has had a significant impact across the veteran community and was heavily supported by DFWA Queensland. The effect of this decision is that veterans' invalidity payments are recognised as lump sums with beneficial tax treatment instead of as a superannuation income stream. And this has had a positive impact for the majority of affected veterans. Secondly, Schedule 9 also extends the Douglas decision to revisionary beneficiaries, being the spouses and children of deceased veterans who were receiving invalidity benefits. And thirdly, Schedule 9 removes any potential disadvantage to a minority of veterans as a result of the Douglas decision through the implementation of a veteran's superannuation invalidity pension tax offset. This offset ensures that affected veterans are not worse off as a result of this change in legislation. There are two areas of Schedule 9 which are not supported by DFWA. Firstly, Schedule 9 enshrines inequity under legislation, where the date of payment of invalidity benefits determines whether a veteran will receive preferential tax treatment. The proposed amendments only apply to those veterans whose invalidity pay commenced on or after the 20th of September 2007 and do not go far enough to extend this treatment to members whose invalidity payments commenced before this date. These veterans have had the same service but will receive a different tax outcome as the result of this legislation. Secondly, the superannuation schemes covered by Schedule 9 are restricted, which means that newer members of the ADF will be unable to access this beneficial tax treatment. The amendments specifically cover the Defence Force Retirement and Death Benefits Act of 1973, DFRDB, and the Military Superannuation and Benefits Act 1991, MSBS. Since 2016, new members of the ADF have had no option to join these schemes and instead have access to insurance via ADF cover. At the time of closing access to MSBS, the government assured ADF members that ADF cover is designed to be consistent with the death and invalidity benefits provided under MSBS. Schedule 9 mandates a different treatment of invalidity benefits for those in ADF cover, and we believe this is against the government's intent at the time of its establishment. We suggest that the committee should extend the effect of the Douglas decision to those on ADF cover, being the younger contemporary veterans and those into the future. We also believe they should extend the effect of the Douglas decision to DFRDB and MSBS invalidity benefits that commenced before the 20th of September 2007, being older veterans, and should continue the inclusion of revisionary beneficiary inclusions and the veteran superannuation invalidity pension tax offset in any final legislation. Obviously, any amendments required to achieve these outcomes should need to be developed through Treasury. Thank you.
Thank you very much, Ms Bowden, for your opening statement, and I'll kick off with some questions. And I appreciate your opening statement where you say that there's some complexity here and there are some parts of Schedule 9 that you support and that there are some parts that you don't support. And I'll make sure that there's an opportunity for witnesses to speak to both today. And I might be a little bit in your hands, Ms Bowden, as to where best to direct the questions.
That's fine.
Just starting with the part of your submission, the aspects of the schedule that you support. You do support the part of the bill that confirms the Douglas decision, allowing veterans who received a lump sum to continue to receive their favourable tax treatment. Are you able to explain to us how this assists that group of veterans?
Well, I'm sorry, John, feel free to jump in here, but from my perspective, there has been significant delays in whether it's CSC, ComSuper, or the ATO in implementing the Douglas decision. From the time that the court case was finalised in December 2020, ComSuper didn't start implementing that until May 2022. So I don't know that that part is necessarily needed in legislation. The court decision has already been made and it has shown what the previous legislation exists. But if it assists government agencies in implementing the court case decision, then that is positive. John,
Okay.
anything to add in that? No? Okay. No, you're on mute.
Yes, the Douglas decision benefited about 8,000 current people receiving the invalidity benefits, and there was about 400 who were adversely affected. And that is the law as it is at the moment, but it is just to a select group. Now, I can give you an example of the comparison of what happens. If we take, say, a member who joins at 18 with an annual salary of about 68,000, and then something goes tragically wrong, and they are injured, and they are medically discharged, and they're also certified as that they are most unlikely to ever work again in their calling due to their training or experience, and they have had an entire career prospect and plans for the future gone. Now, if that fella's discharged, or that veteran is discharged on the 22nd birthday, 2 doctors certify they're unable to be gainfully employed. Now, the invalidity benefit paid, regardless of the scheme, MSBS, DFRDB or ADF cover, the invalidity benefit paid is $63,000 per annum, roughly. And that is the same for each of those schemes, give or take about 100 a year. Now, those in ADF cover pay about $10,800 of that in tax. Those in MSBS or DFRDB with payments that started before 2007, they pay around about the same amount, a little bit less in tax. But those in MSBS where the payments started on or after the 20th of September get the beneficial treatment. And in this particular scenario, they would pay 0 tax on that element of their income. Now, the thing is, they get the same benefits. All of those get the same benefits, about $2,420 a fortnight. But after tax, they get about $1,995. So it's a difference of about $425 a fortnight for the rest of their life. Now, it's important to realise that these invalidity benefits are from CSC, and they are offset against any incapacity payments paid by DVA, which means that if they get these, the incapacity payments by DVA are reduced by the difference. These are just indicative examples, and everybody's situation is different, but it gives you a ballpark idea of the beneficial tax treatment. We just can't see there's any justification for this arbitrary discrimination against veterans who are all in the same boat. We think it has to be fixed.
Okay, thank you very much, Mr. Lois, and that example that you gave with the specific benefit amount per year and how it applies to people in different categories is useful for the committee. Essentially, this schedule is about trying to fix a particular issue around a particular group of people affected around the Douglas decision. But is it your general submission that the benefits that flow from that to the particular group that was affected should now flow on to everyone, irrespective of whether they're pre-2007 and irrespective of what's the fund through which they receive their invalidity payments?
Yes. Our position. Sorry, our position is that the benefits paid by to veterans in receipt of an invalidity payment doesn't meet the requirement of a superannuation income stream. It is not permanent for life. It is revocable by the government, and it is not at a set set salary. So given that it doesn't meet the requirements of an income stream in any of the superannuation streams, which Defence Force veterans sign up to, this benefit should be applicable across all veterans in receipt of an invalidity payment.
Thank you. So
Can I just add a little bit there?
you can, yes.
The thrust, part of the thrust of this legislation is, in fact, well, it just reinforces an already existing court decision, but it also extends it to the families should that veteran die, and it fixes up a small number of veterans who are adversely affected. But I believe the main purpose of this is to prevent the spread of the Douglas benefits to a whole lot of other systems, and that was made pretty clear in the Minister's speech in the House, and it seeks to bound it and actually entrench the current system so that ADF cover can never be treated the same way. And I think it's quite a deliberate act on the government's part on this.
Okay. I'll come back to the evidence that you're giving on what you've just said about the broader consequences there as you see it, and your submission that this creates inequity between different groups of veterans. I do just want to go to the specifics of this schedule, and you mentioned, Mr. Lois, about how the schedule extends benefits to spouses and children in the event of the death of the veteran. Can you just explain your understanding of how that works and how that would assist a typical family?
Yes, well, if a veteran is receiving invalidity benefits and who's got dependents, wife, spouse, children, and if that veteran dies and he'd been receiving that beneficial tax treatment, if the veteran dies, the family receive what we refer to as reversionary benefits, which is a pension for the spouse and a pension payments to the children up to a certain age, 18 or 25. I'm not sure which. I think there's education criteria there. And this benefit of this legislation extends that tax benefit to those payments as well. Otherwise, they would have been excluded, and that's very welcome.
Okay, thank you. And again, I'll come back to your broader concerns that you've been giving evidence about today. You mentioned, Mr. Lois, the smaller number of people. I think you put a number of 400 or so on it who were adversely affected and liable to receive a negative tax outcome as a result of Douglas. Do you think that this does broadly fix that problem for that small group?
Yes.
Okay. And so your submission, if I understand it, is that while this schedule fixes these issues and extends benefit to families and allows those who received a lump sum to continue to receive their favourable tax treatment, your concern is that in trying to fix that, there's an inequity created between different groups of veterans. And so is it the case that you support the provisions of the bill but you'd like to see them extended? Is that broadly the submission?
Yeah, yep. That's correct. We've got a situation now where most of the currently serving ADF, which is under strength at the moment, are either in MSBS, and I think there's a couple of hundred still in DFRDB, but everybody since 2016 are put into ADF cover. Now, you've got the situation where you could have two people serving side by side, both get injured or critically injured at exactly the same time, and they're medically discharged and they get exactly the same invalidity benefits, but lo and behold, one has to pay more tax than the other. And that's just nonsense for that to happen.
Okay, I think I understand the submissions that you are making from your written submission and from your evidence today. I don't think I have further questions. Ms. Bowden or other witnesses, was there anything that you think we didn't cover today that you wanted to make sure was on record for the committee?
Yes. Oh, sorry, go on. Sorry, Kate.
I was probably going to suggest that there were a number of other submissions that specifically addressed Schedule 9. I know some of them went into the legalities of why other schemes should be covered in terms of getting this beneficial tax treatment. So I would refer back to some of the submissions that have been provided by other parties as well against regarding Schedule 9.
Thank you.
If I could add just one other thing. We're specifically concerned about the equitable treatment of veterans currently serving together and those who have been medically discharged in the past. It just seems you would not design a system to produce that outcome if you're coming at it from the veteran viewpoint. And also, it's sort of created disharmony amongst what was harmony between the different acts, the different bits of legislation. And the Royal Commission into Veteran Suicide has got a focus on the complexity and the disharmony, and that matter needs to be addressed in veteran entitlement, not just DVA, but it says in the veteran entitlement system, and this is part of the veteran entitlement system. And we have now legislation which doesn't attempt to fix this disharmony, but instead entrenches it. And I put it to you that this goes totally against the spirit and the intent of what the Royal Commission is focusing on. And these veterans, they'll never work again. They have been medically discharged. They have been, in a sense, rejected by their team and kicked out, so they've lost all of their team support. It is a huge change for them. And they are the most vulnerable group at risk of mental health problems and suicidality. And this has been recognised in some of the reports submitted to the Royal Commission.
Yeah.
This goes against the spirit of the Royal Commission.
Thank you.
I would, if I could just echo the words of John and Kate, that the inequities here and also the mental anguish that may or does occur as a result of some of these things that can happen. So it's really about making sure that there is no discrimination regardless of which ADF superannuation fund that you're in, if a member is medically discharged through injury or illness.
Okay, thank you very much. Ms. Gaudry, Mr. Lois, Ms.
Sorry, can I make one last comment? Just in relation to the CPA submission, which recommended simplifying the tax treatment and removing the lump sum benefit for veterans and changing it into an income stream, we would object to that position. The reason that it's been recognised as a lump sum is because it doesn't meet the requirements of an income stream, and there would be further ramifications of what the government would need to do to change and make them non-revocable payments for invalidity benefits if that was a path that they wished to go down. But under the current arrangements for the superannuation scheme, where the government is able to revoke an invalidity payment or to change the amount of an invalidity payment, we fully believe that the lump sum approach is in accordance with the legislation that already exists.
Okay, thank you very much. I think through your evidence today, your written submission, your reference to other submissions as well, you've made your position very clear, and we thank you for that. And I know the committee would join with me in thanking you for the advocacy that you do every day and that you're doing in this hearing as well for the veteran community that you serve. And we very much take seriously the issues that you've raised, Mr Lois in particular, about the broader context in which veterans' payments are occurring as well. So we thank you again for your evidence today and for the advocacy that you perform through your organisation. Thank you for appearing as witnesses. The committee has agreed that responses to questions on notice should be provided by close of business Thursday, 23 of February. And we'd ask that you now disconnect from the video conference, and if you'd like to continue to observe the hearing, you can do that through the live stream on the Parliament's website. And again, thank you very much for your evidence today.
Thank you. Thank you.
I now welcome by video conference representatives from Chartered Accountants Australia and New Zealand and CPA Australia. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard, will you please state your full name and the capacity in which you appeared today? And we might start with the Chartered Accountants Australia and New Zealand.
Thank you, Madam Chairman. My name is Tony Negline. I am Superannuation and Financial Advice Leader at CAANZ.
Thank you, Mr Negline. And the representatives of CPA Australia, if you could state your name and the capacity in which you appear. And I think, Mr Webb, I think you were on mute just then.
Thank you, Chair. My name is Richard Webb. I'm the Policy Advisor for Financial Planning and Superannuation at CPA Australia.
And you're on mute, which we did ask you to do while you were waiting kindly for us.
Thank you, Chair. I'm Ram Subramanian. I'm the Senior Manager for Reporting and Audit Policy at CPA Australia.
Thank you, Mr Subramanian. Do either of your organisations have an opening statement, starting with you, Mr Negline?
Thank you, Madam Chair. I will defer to Richard to open proceedings.
Great. Mr Webb, thank you.
Thank you, Chair. And well, just to let you know, we will be, myself, Mr Tony Negline and Mr Ram Subramanian will be providing an opening statement jointly. We appreciate this opportunity to appear before the committee today and would be pleased to answer questions on our submission on the bill. Our submission is focused on Schedule 6 and Schedule 9 of the bill, and we will aim to address any questions from the committee on these parts of the bill. CPA Australia represents the diverse interests of over 170,000 members working in over 100 countries around the world. Whilst the submission which we made to this inquiry is on behalf of our members, our overriding responsibility as a professional accountancy organisation is to the broader public interest. In furthering the public interest, we work with regulators, standard setters, members and other stakeholders to address matters relevant to the accounting profession.
So Chartered Accountants Australia and New Zealand is a similar organisation to CPA Australia. We have around about 130,000 members working predominantly in Australia and New Zealand, but also like CPA Australia all around the world. We also advocate in the public interest. And many of our members provide a wide range of services to APRA regulated funds and also to self-managed superannuation funds. We might do financial and accounting, management accounting, tax, audit, investment advice and so on. Some of our members work for the tax office, for APRA and so on, but it would be fair to say that the majority of our 130,000 members are users of the superannuation system rather than working within it.
We generally support the proposals in Schedule 6. We believe these proposals have the potential to improve the accountability and transparency of registrable superannuation entities. I will refer to them as RSEs from here on to keep it simple, if that's okay. We commend the government for listening to stakeholders, including ourselves, and removing the previous proposals for interim reporting and sub-fund reporting for the current bill. We would also like to commend the government for delaying implementation of these new requirements to ensure proper consideration is given to the detail. We'd like to note that RSEs are currently making significant audited financial disclosures to APRA for prudential regulation purposes. Whilst we appreciate the focus of the financial reporting and audit requirements in the bill is different, we request that there be minimal, if any, duplication between what is currently being reported to APRA and what is being proposed in the bill. Thank you.
So our substantive feedback in respect of Schedule 6 is that whilst we agree that there needs to be clarity and transparency brought to reporting by RSEs, there does need also to be proper consideration of the cost inherent in the implementation of this bill, as the ultimate bearers of the initial and ongoing costs of implementation are the members of Australia's 2,000 or so registered superannuation funds. In addition, we raise concerns around the imposition of strict liability for breaches of the audit and assurance standards and recommend that auditor liability settings be aligned with the rest of the world. Finally, we consider that, in light of the Minister's announcement in November to align reporting requirements of funds with publicly listed companies, we note that there is considerable duplication and misalignment inherent in various reporting requirements and recommend that a whole of government view of reporting should examine this in context as part of this suite of recent transparency projects.
So that brings us finally to Schedule 9. And now, obviously, Schedule 9 is in relation to the taxation of invalidity, mainly in relation to invalidity benefits from certain type of superannuation schemes. The complexity of Schedule 9 was borne out by the Burns and Douglas decisions before the AAT and also before the full federal court. Now, the problem we have with Schedule 9 is that we have the SIS Act and its regulations, we have the Income Tax 1997 and its regulations, and we also have very complex benefit design. And matching those three things together is not an easy exercise. And the problems that exist in the pension and annuity regulations in the SIS Act and its regulations and the taxation of those in the Income Tax Assessment Act have been a known problem since 2007, and our associations and others have over the years called for these matters to be thoroughly reviewed. Unfortunately, no government has actually acted upon those requests. From time to time, piecemeal changes have been made, for example, in 2018, as an example, to implement government policy initiatives or to plug holes that have emerged. Now, we think Schedule 9 is a missed opportunity, and after considering the submissions made by the various defence associations and other interested parties to this inquiry, we suggest that Schedule 9 should be removed from the bill for the time being, so the root cause problems created by ongoing inconsistencies between the SIS Act, the Income Tax Assessment Act 1997, and also the complex benefit design, not only of MSBS and DFRDB, but also of other similar type of schemes, such as the public sector superannuation schemes, can be thoroughly addressed and properly identified and addressed. So we're happy to take a question, Senator.
Okay, thank you very much for that opening statement. I'll just start with a few questions in relation to Schedule 6. So this was a proposal that was first announced in August 2021 and has had, as I think you mentioned, a fairly significant consultation. Are you broadly satisfied with the changes to the exposure draft that were made in the sort of previous round of consultation in terms of commencement? And there were also some changes in relation to reducing the frequency of the reports that needed to be provided and the number of reports that needed to be provided in relation to sub-funds. So are you generally satisfied with that consultation process and the changes that were made to the exposure draft previously?
Chair, I'll probably start off by saying the answer is generally yes. Generally, the direction taken from the previous bill, which was previous consultation from 2021, and the revised proposals that were consulted publicly last year, the differences and the changes we are very supportive of.
Okay, thank you. More broadly, the intention of this schedule, going back to 2021, is to improve transparency for members of super funds. Given the size and the compulsory nature of superannuation, do you support that objective of improving transparency for members? And do you think that these changes will give ASIC the powers that they need for monitoring and enforcement of compliance with the related accounting standards?
I'll start off by taking that question, Chair. In very brief terms, yes, the answer is yes in improving transparency to members of super funds by requiring financial statements to be made available both publicly and to ASIC. It just has to be kept in mind that the financial statements that are being prepared in accordance with Australian accounting standards, the objective of those financial statements is to meet the needs of investors, lenders, and others in making their decisions as to where they put their money, in simple terms. So if that basic objective of financial statements is going to be met as a result of these requirements, then we would support these requirements for that reason.
Can I just add to that what Rap says is perfectly correct, but there's also the issue of transparency. Now, it is free to any regulated superannuation entity to actually issue annual reports, including annual financial statements to members now if they want to do that. In some respects, it's voluntary if they send it out to all members. But if a member asks for those statements, then they are required by the corporation's regulations to actually send them to members or make them available, but only to members. So one of the good things about Schedule 6 is that it will require funds to actually publish this information on their websites. So that in itself will actually create a greater level of transparency so that individuals and their advisors will be able to go in and actually check the financial statements themselves in exactly the same way as occurs for private entities listed, say, on the stock, or public entities listed on the exchange. It allows for that analysis to take place. At the moment, if you want any information about these funds, in some cases, you actually have to become a member of that fund in order to have it exposed to you. Now, that's a bit of that's not really fair. Now, making it a requirement to put it on websites and available and so on and so forth is a good thing.
Yeah, thank you for that. So you're essentially saying that the fact that these new reports are not only lodged with ASIC, but they're made publicly available, not just to members of funds, that enhances broader industry analysis and scrutiny.
Correct.
Just to add to what Mr. Negline has just said, we'd like to just note that many super funds already do that. So they do make available annual reports on their websites, etc. In a sense, this is formalizing that procedure. So it's making sure that all RSCs are on the same platform and they're all doing the same thing. So in a sense, that is a good thing. We have in our submission highlighted the issue of cost, which I think does need to be taken into account in finalizing these proposals. Because whilst transparency is most definitely a good thing to have, where possible, there needs to be consideration of the existing reporting that super funds already do and how that might be repurposed for the purpose of public disclosure.
Right. So I was just going to sort of check my broad understanding that you support the broader transparency, agenda, given the size and the complexity of super, and you're supportive of these reports going to ASIC, and you're supportive of them being made publicly available for the reasons that we've just said. So you're broadly supportive of the super sector being aligned with the general corporate sector in terms of their reporting for ASIC, I think. Is that right so far?
That's correct.
Yeah,
Yep.
that's correct. But we should add that implementing these things, I think it describes it in the explanatory memorandum as being of low cost. And we think that there are costs. It's an unknown cost from fund to fund, because depending on how well they are set up behind the scenes from a financial accounting perspective and then an auditing perspective. But there will be additional cost for funds, and there's also additional cost for ASIC in order to enable them to accept these reports, analyse them and assess them. And obviously those costs will then be passed through to the RSCs through the ASIC industry funding model. So we think it's a bit of a stretch to actually describe the implementation of these changes as having low cost. There is definitely a cost for everyone involved in the whole implementation of this. And given the substantial penalties that potentially apply for getting anything wrong contained within Schedule 6, funds will want to move very, very carefully to ensure they don't do anything wrong, because to do anything wrong sees those potential penalties come into view, and no one needs that in their life.
Okay.
So funds will want to be very careful.
And it sounds like the feedback that you're giving today is the feedback that was given by yourselves and others in the original consultation on the exposure draft back in, I think, 2021. We just went through some of the changes that were made there around delaying the commencement to allow for implementation and reducing the reporting load from twice a year to once a year, and removing the sub-fund requirement to try to ease some of those issues that you've raised. Is there some further sort of easing of the requirements that you're seeking that's further to that? And then I guess how would you balance that with the need that you've committed to and agreed with, and that we all agree with, which is about the need for greater transparency in relation to the sector?
Chair, perhaps maybe I should just, I suppose, state from the outset that I think this is a really good example of where we do need to actually look at the transparency projects that are in place at the moment and take I suppose a whole of world look at them, because there are a number of different requirements that are in place for super funds at the moment in terms of reporting to APRA and to ASIC, and in a lot of instances, some of the various different items of information that are being asked to be reported can actually be quite different depending on the definition used. One of the things that hasn't come into place at the moment is a requirement in the SIS Act, which is Section 29QC, which is supposed to bring the information that's presented to either regulator into line with each other. Unfortunately, it needs regulations to be made to work, and that means that there are certain things that ASIC are going to want and there are certain things that APRA are going to want, and they're not exactly going to match because of the definitions that are attached to them. So one of the things I think we need to keep in mind when you undertake new transparency projects such as this, which we think are a great idea, is that these actually do need to be sort of coordinated in some way from the top down, I think. Another thing I suppose I should mention is that the broad intention of a reform such as Schedule 6 is to bring super funds, which are trusts, into line with listed companies, which are companies. There are certain bits of item in the financial reporting that are not necessarily going to match up there. So, of course, we would expect that there would be a consultation process which would actually kind of draw out where some of the differences are and try to line them up a little bit better than what they currently are at the moment, just so that people who are already used to using, statements from financial statements from listed companies would probably have more of an idea about what to expect when they're looking through the financial statements of a trust such as a super fund.
Okay. So you, in relation to Schedule 6, you broadly support the transparency thrust and the ASIC reporting and the public reporting, and you're satisfied with the response to the exposure draft and the changes that were made there, but you'd like to see some further efforts around sort of streamlining or aligning this reporting with the reporting that occurs with APRA already.
Yeah, that's a reasonable summation, Madam Chair, and an honest appraisal that the implementation of this is not low cost, and ultimately all of the costs that are generated in this are actually going to be borne by fund members.
Okay, thank you. I'll just go to Senator Bragg, who has questions.
Oh, thanks. Look, just very quickly, because this has been a long session, I just wanted to know whether related party transactions would be captured in the disclosures required under Schedule 6.
I'll take that question if I may, Senator. So when you're preparing financial statements in accordance with Australian accounting standards, there is a specific accounting standard on related party transactions, which sets out the requirements for disclosure of related party transactions. So if a super fund is going to be preparing financial statements that comply with Australian accounting standards, they will make related party transaction disclosures that are in accordance with that particular standard, which would be AASB 124.
Okay, thanks a lot. Thank you.
Oh, thanks, Senator Bragg. I'll just go to some questions around Schedule 9. I think in your submission, your written submission, you were welcoming broadly the clarity that the bill provides for the cohort of veterans that the schedule of the bill is dealing with. And then in your opening statement, you've described a missed opportunity to deal with broader issues around benefit design and complexity going back over 15 years, back to 2007.
That is correct.
I guess, I guess there's always a challenge for policy making about whether to try to deal with something that's in front of you and implement a narrow sort of solution to that, or whether to potentially hold that up for a much broader review of the type that you're seeking of 15 years of what you've described as complexity around benefit design. So I guess I'm, wondering what your concerns are really around proceeding with this clarification for this cohort of people now, and why you think that in some way might impede the broader policy discussion that you've raised. Can we not do both, fix this issue for this cohort now and then also engage in the larger policy discussion that you've flagged?
That is certainly, so it is certainly obviously open to the government, Senator, to actually do that, to make changes that are required in a piecemeal basis while there is a broader review going on. I guess our point is that we can continue to do the band-aid solution as you know, Schedule 9 arguably is, or we can actually fix the ultimately seek to fix the problems that actually exist at a broader level, which have been, as we said, sort of identified for over a number of years. So it's a balancing act. And I guess on balance, we decided that on reflection of looking at some of the submissions that had been made to the committee, that maybe there were a few elements of the bill in relation to how it affects some recipients of invalidity benefits was broader than what we actually expected. So we thought, hang on a minute, these sorts of problems are going to continue to exist for some time while we have the disconnect between the SIS Act, the Income Tax Assessment Act, and maybe to a lesser extent the complex benefit design that exists in these public sector schemes, but also potentially other schemes overall. So that's why we think it might be better long term to do the big job rather than do the band-aid job.
Okay, I think it's a reasonable policy position to take to suggest that a broader set of issues be dealt with, or that this be dealt with in a broader context. For the purposes of this particular inquiry on this schedule, can I just ask whether you agree that the measures, I guess, do what they're intended in relation to this particular cohort? So, it's trying to fix a negative tax outcome for a minority of veterans affected as a result of Douglas. It's trying to extend benefits to spouses and children, which was discussed by the previous witness. It's trying to maintain the favourable tax treatment for those who did have it. Are you broadly supportive of the schedule in trying to assist those groups?
I think our problem, Senator, is that we support Schedule 9 if it operates as intended and as you have just eloquently described. Our concern is that there are some individuals which we haven't quite got a handle on the size and how and so on and so forth because of the it's incredibly difficult to go through all of these different strands of laws and so on and make sure you've got all the ducks lined up. So we are concerned that there are some unintended consequences that, to be frank, we actually haven't got a handle on as yet. So that's our overriding concern. So we do support it, subject to what I just said. Our concern that maybe there's some problems that have been put into it.
Okay.
Problems that have accidentally come about as a result of trying to again do a band-aid.
Okay. I think you're describing in your submissions the sort of perpetual policy problem of trying to fix something in a narrow sense to get on with doing it, or trying to sort of address the whole complexity of something larger. And I guess in this case the government is trying to take initially a narrow view of fixing the Douglas decision in the way that we've described. I think your submission is raising, genuine policy questions about what's the best way to proceed to try to deal with all of the complexity and assist those groups or assist those groups and then deal with the broader complexity. So that it seems like a fair submission that you've made. I think that concludes the questions that senators have for you today. So Mr Negline, Mr Webb, Mr Subramanian, we very much appreciate your submissions and all of your evidence for the committee today. We thank you very much. The committee has agreed that responses to any questions on notice should be provided by close of business 22 February. And I'd ask that you now disconnect from the video conference, and if you'd like to continue to observe, you can do that through the live stream on the Parliament's website. But again, thank you very much for appearing today.
Thank you very much.
The committee will now suspend until 1:15 p.m. I now welcome by video conference representatives from the Association of Superannuation Funds of Australia. I understand that information on parliamentary privilege and protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, would you both please state your full name and the capacity in which you appear today?
Thank you. My name is Fiona Galbraith and I'm the Director of Policy at the Association of Superannuation Funds of Australia, or ASFA for short.
Thank you, Ms Galbraith.
And my name is Julia Stannard. I'm a Senior Policy Advisor with ASFA.
Thank you both for being with us today. Did you have an opening statement that you wish to give?
Just a brief one. I'm aware that you had the combined accounting bodies in the session before, so I'll truncate ours a little. So first of all, thank you very much to the committee for the opportunity to appear before you today. Just by way of background, ASFA is a non-profit, non-partisan national organisation whose mission is to continuously improve the superannuation system so all Australians can enjoy a comfortable and dignified retirement. Our membership is across all parts of the industry, including corporate, public sector, industry and retail superannuation funds and associated service providers, representing almost 90% of the 17 million Australians with superannuation. So turning to the bill, which is before us, ASFA's submission to the committee focused on two schedules of the bill, Schedule 6, with respect to financial reporting and auditing requirements, and Schedule 9, which containing amendments to the taxation treatment of military and some other super benefits to reverse the effect of the Douglas decision, as it's known in short. So turning to Schedule 6 first, ASFA supports the principle of the transparency of financial information, both to members of the super funds and more broadly. When it comes to the bill, however, there are some definitions of expenses utilised in, this is more just an awareness thing, I guess, for APRA in particular to make public. There are, the superannuation funds have to comply with a multitude of reporting obligations, of which the accounting standards are only one. And there are some differences in the between the accounting standards and, for example, the superannuation data reporting standards, where the super funds have to report data to APRA, in particular with respect to expenses. And so given this, we just wanted to flag that that there are those differences, and therefore some expense items may not reconcile from one source to another, given that the definitions are different, and call for the fact that it's particularly important for APRA to acknowledge those differences, especially in the light of the proposed super transparency report that will be coming up. Schedule 9, of course, confirms the treatment of certain defined benefit pensions following the decision of the full federal court in the Commission of Taxation against Douglas, or v. Douglas. The decision found that, contrary to policy intent, invalidity pensions paid under two military schemes were not superannuation income streams, within the definition introduced into legislation back in 2007 as part of the Simpler Super reforms. So as a result of this, the pensions were taxable as a series of lump sums, not as an income stream. This issue has been identified as applying to some invalidity pensions payable by super funds other than the two military schemes as well. So the amendments are to clarify the tax treatment of these pensions and will provide certainty to the recipients of the pensions and the funds that pay them, but they will require action from the funds and from the ATO. For many recipients of these pensions, there will be a tax impact. Now, we should bear in mind that we're talking here about disability pensioners who may be somewhat vulnerable in terms of their health and financial situation. So it's important to ensure that, to avoid causing them further distress, the necessary changes can be implemented in a measured way. So we welcome the mechanism in the amendments for the Minister to provide a transition period for implementation. We are concerned, however, that it only applies to the 22-23 and 23-24 financial years. 8 months of the 22-23 financial year have already passed, and the amendments have not yet been considered by the Senate. Given this, in our view, the transition period should be extended to cover the 24-25 financial year as well. We thank the committee for the opportunity to appear before you today and welcome any questions you may have.
Thank you very much, Ms Galbraith, for your opening statement. I'll just start on with some questions on Schedule 6. I think you said in your submission and your opening statement that you're broadly supportive of this transparency measure. So, you know, given the size and the complexity of the superannuation sector, do you think that this measure has the impact of increasing transparency in general?
Yes, it does. Members have indicated that they're broadly comfortable with it as a transparency measure. So yes, it's just, I suppose it's more bringing to the attention of the committee and more broadly the fact that that super funds report under a variety of different sources of obligation and so different requirements will always lead to issues with what appear to be discrepancies, but in fact are driven by different definitions, and therefore things may not always align or reconcile. And I guess that's the main concern that members raise with us, that they're happy to do this, but just note it may look different to reporting over here or reporting over there.
Yes. So you've just confirmed again what you said in your opening statement about the different reporting to ASIC and APRA, and your suggested way of dealing with that, as I understand it, is that it's important for APRA to explain why is it the quarterly reports will look different on some items as opposed to these annual reports to ASIC?
The quarterly reports may well, because they're driven by obviously the data that the funds report to APRA and not by the accounting statements. But in particular, we've obviously got the super transparency report that's been announced, but we haven't seen the details of, and that in particular may be a source of some potential confusion depending on the basis on which that's done. If it's APRA doing it, presumably they will do it from APRA data reported to APRA through the APRA data reporting standards that may be different to the data that appears in the financial statements prepared in accordance with the accounting standards.
Okay, so you're flagging a future issue with the proposed super transparency reports?
Yes, that's a main concern that members have, that because it's another source of obligation with different definitions, it may look different, and that there's a valid reason behind that in the detail, but it may look different at a headline level.
Okay, so I guess sort of noting that issue and recognising it whilst also just sort of putting it slightly to the side for the moment, do you find that these changes are broadly consistent with the existing fiduciary and statutory obligations of funds? You said that the funds were generally sort of happy to do this reporting. Is it generally consistent with what they do?
I mean, they prepare accounts in accordance with the accounting standards, so their financial reports anyway. Yes, I mean, it's just, I guess, as a broader proposition, I guess the funds are sometimes struggling with a degree of compliance burden that arises from this variety of different sources of reporting and disclosure obligations. So down the track, it might be an idea to maybe look at aligning some of them, or even that some might overtake others. But obviously, maybe it's not properly classified as an interim measure, but certainly as a particular measure, they're comfortable with doing that. I guess it also does reflect on the Wallace Twin Peak style of supervision, that when you have two different regulators, sometimes there's going to be a degree of duplication and overlap. Some of that's unavoidable, some of it does add to extra costs, particularly when you are dealing with things like different definitions, because your compliance regime then has to have different processes to make sure you pick up the right definition for the right obligation, and that is where sometimes the added cost in preparing and checking different reporting is required. So down the track, there may be opportunities to maybe look at reconciling some of those and having one source of truth with one regulator sharing with the other one.
Okay. So if I can try and summarise that position, that ASPA is, and your members are broadly supportive of transparency measures in general, of this transparency measure as well, in terms of providing this opportunity for a scrutiny, more broadly by making these reports to ASIC, but you're flagging particularly as sort of a future issue of the potential for a sort of reporting clash between sort of what you're reporting to ASIC and what you're reporting to APRA, and how people might understand that, and you're flagging that some work could be done in the future to sort of either clarify that, for APRA to either clarify what it's publishing, or some further work to sort of align the reporting in the future.
Yes, that's exactly right. It's yes, that sums it up very nicely.
Okay, and just in terms of the possibly casting your mind back to 2021 and the original exposure draft, and noting that you've raised, I think, if I understand it, you're raising some sort of compliance cost issues, but you're not suggesting that they're huge, and you're suggesting that members are happy to do it. In relation to the previous consultation, are you broadly happy with the changes to the first exposure draft, which limited the reports from 2 to 1 and removed the additional level of reporting on sub-funds, and also gave a longer lead-in time to the reporting?
Yes, that would have been an enormous compliance burden for superannuation funds, and our initial submission on the exposure draft of the bill reflected that. So I guess the overarching response of our members to the bill as introduced, as opposed to the exposure draft, was relief that both the obligation to do half-yearly reporting and the obligation to report down to sub-plan level had both been removed, because they were extremely onerous, to say the least, and where the cost would fairly certainly outweighed any potential benefit, especially given the level of data reporting that is done to APRA anyway. So they would have represented a material uplift in cost. And so, yes, we're very supportive of those having been removed from the exposure draft when the bill was finally tabled. Okay,
thank you. In relation to your comments on Schedule 9, the taxation of military superannuation benefits, you've raised some issues there around communication around this, particularly to veterans who, by definition, are, experiencing disability. Can you elaborate on that? What do you see as the concerns there, and how government might address them?
With this one, I'll refer this to my colleague Julia, who's the tax expert at ASFA.
Thank you.
Thank you, Fiona. Chair, the concerns we're alluding to there are that while this measure has been described as relating to military superannuation benefits, it is also an issue that may apply to some non-military schemes in relation to defined benefit invalidity pensions. That's acknowledged in the explanatory memorandum. Certainly for the veteran community, they are well aware of the Douglas decision. There's been advocacy over a number of years amongst that community, as highlighted in some of the submissions to the committee. That community is well aware of the impacts, and they are well aware of these amendments. There may be some pensioners who do not consider themselves to be part of that community, but their pensions may be impacted by these amendments. It may come as a surprise to them that the effect of some of these amendments may alter the tax treatment of their defined benefit invalidity pension. That's a communication issue, but it's also points to why we are asking that the transition period be extended to allow funds who are in this situation to prepare ways to support their impacted pensioners, and for those amendments to go through in a measured way.
So can I just ask whether it's your submission that the schedule does, I guess, what it was intended to do. So you've raised some potential, perhaps unintended consequences. Can I just clarify your position in relation to how it deals with those veterans who already had a favourable tax treatment, those who were disadvantaged, who were being provided with the offset, the extension to spouses and children in the case of death of the veteran? Is it your submission that the bill does what is intended in relation to those groups?
Yes, it is our understanding that it does achieve its intended aim. I'm aware of the submissions of the various Defence Force advocacy bodies that they have some concerns around whether that intent is appropriate or not. But it is our understanding that the measures do achieve what the stated intent in the explanatory memorandum is. It's simply, I guess, an awareness issue that we've talked about this very narrowly, typically in the context of the military schemes, and there is an awareness needed that it can apply to some funds other than those military schemes.
Okay, that's very helpful advice to the committee to look at that issue further that you've raised. So thank you for that. I think Senator Bragg may have questions.
Yeah, look,
Senator Bragg.
Thanks, Rheta. So just in your submission, you talk about the announcement of a super transparency report. And you say that the government has not released any detail on that report. So what do you know about that report?
Only, Senator Bragg, only what was announced by the Assistant Treasurer back in, Julie, you probably help me, November or December, I can't remember, late last year. There was an announcement that there was going to be a super transparency report, but we haven't seen any further details. And APRA would be producing it.
Right, so this was announced before the regulation on transparency was disallowed.
Yes, it was late last year sometime.
Okay, so does the industry assume this thing's going to happen? Or is that just designed to be a bargaining chip in the Senate?
Well, all we've got to go on is Minister Jones's announcement. So we haven't seen an announcement to say it's not going ahead. I guess it may not, but we haven't had an announcement either way. So,
yeah, well, he's not too good on following through from time to time, I have to say, regrettably. That's great. Nice to see you. Thanks for coming.
Senator Bragg, you were too quick for me to pull you up on your negative comments about the minister. You got them in too quickly. I think that if that concluded Senator Bragg's questions and comments, I think it also concludes my questions for you as well. We very much appreciate you coming and giving evidence in front of us today. The committee has agreed that responses to questions or notice should be provided by close of business Thursday 23rd of February. And again, we thank you very much for your time and your evidence today. If you'd like to continue to observe the hearing, you can do that through the live stream on the Parliament's website. And at this point, we'd ask that you disconnect from the video conference and go with our thanks.
Thank you, Senator.
Thank you, Senator. I now welcome in-person representatives from Treasury. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. As you come to the table, I'll possibly just do a bit of tap dancing in the hearing. We are running a little bit ahead of schedule, which is always welcome and always good that you're there a little bit early in the event that that happens. For the Hansard record, Would you please state your full name and the capacity in which you appeared today, perhaps starting with you, Mr Healy?
Sure. Brian Healy, Director of Retirement Advice and Investment Division.
And Luke Spear, the Branch Manager of Members Outcomes and Governance Unit.
Great. Thank you very much. I'm assuming that you don't have any opening sort of statements and you're happy to proceed straight to questions. I'll start with some questions about Schedule 6. What is the broad objective of this transparency measure in relation to superannuation?
So prior to the amendments in this schedule, superannuation funds were subject to different financial reporting obligations in public companies and registered schemes. And in particular, there was no requirement for registrable superannuation entities or RSEs to lodge financial reports with ASIC or make them publicly available to members. While super funds were required to provide financial information to APRA and continue to do so, this information was not subject to any monitoring and enforcement action by ASIC to ensure compliance with the relevant accounting and auditing standards. And so I think the purpose of this schedule in this bill is to provide additional transparency to members of superannuation funds in the same form as anyone else in the financial system would expect from their corporations, standard public corporations and other financial entities such as managed investment schemes, etc.
Okay. You may have been monitoring the hearing when we had evidence about some different standards in terms of providing information to APRA versus what will now be provided to ASIC. Do you submit that these changes are generally consistent with what funds are already required to do in terms of their audit processes?
So our understanding is that most superannuation funds, if not all superannuation funds, already have audited financial reports of the nature required in this bill, and they are already provided to the superannuation management and trustees. And so we're not expecting this bill will have a huge amount of additional compliance costs, but we do note the concerns from ASFA and other entities that are largely around there is a different set, a lot of overlapping because our prudential data requirements also are based on accounting standards initially, but they do often require slightly different information from a prudential perspective, and that information is provided directly to APRA. So we understand the concerns, and we do understand that APRA are working through their superannuation data transformation project at the moment, are consulting on some of these issues at the moment, or in the process.
Okay. So there may be a solution to the issue of data alignment between APRA and ASIC that can be done broadly by people kind of working together in how they collect data and report it?
I wouldn't want to overstate the ability of APRA. APRA's, they collect data for different reasons that is provided in accounting standards. So there may be very valid reasons for the differences, but this is an active issue that APRA is.
It's a known issue, and people are starting to look at it.
Yes, that's right.
Okay. There's already been some changes made between this legislation and the original exposure draft in response to consultation. Are you able to talk us through the changes that were made, and I guess particularly how they addressed issues around the potential for a sort of compliance cost?
Yes, Senator. So this schedule has a little bit of history. So the original exposure draft was released in August of 2021, and Treasury received 10 submissions from a range of stakeholders. Generally, the key bit of feedback that we received as part of that exposure draft was around the compliance cost concerns. And so there were a number of changes made to the exposure draft relative to the draft that is currently before the Senate. And so in response to the feedback, the following amendments were made. First of all, the commencement of the measure was delayed from the 1st of July 2022 to the 1st of July 2023. The requirement of RSEs to prepare half-year reports was removed, and the requirement for RSEs to prepare financial statements and notes for sub-funds were removed. And we've received a lot of feedback from industry that they were high compliance requirements, and so they were removed. The provisions were made for audit firms and audit companies to also to be appointed as the RSE auditor. My understanding is the original draft only allowed individual auditors, so that was more of a technical change.
Okay.
But that's the summary of the key changes since the exposure draft.
Okay. And on the basis of those changes, that there's a view that the compliance costs between the exposure draft and this draft have been reduced fairly substantially.
Yes, that's right, correct.
I'll just move to Schedule 9, if appropriate.
Ask a question about Schedule 6.
I might be just a second, Senator Bragg, I might be about to advise that you're not the right people for Schedule 9.
Yeah, so we're not the experts on the Douglas issue.
Okay, that's right.
But we can take things on notice.
I'll put some questions on notice for Treasury on Schedule 9. Senator Bragg.
Thanks very much. It's a benevolent dictatorship. Thank you very much. So, what is going to be disclosed about related party transactions?
As part of this bill, Senator?
Yeah.
So they'll be reported in accordance with Australian accounting standards. And so I don't have a detailed definition for you, but there's plenty of examples on superannuation funds websites that already report as part of, in accordance with Australian accounting standards. And so you can get a sense of the information that will be required under this Act if you have a look at some of those documents.
So, but what do you think about, I mean, as you know, right, I mean, the member statement regulation that was made in the last Parliament, which the Minister tried to change, and that was rejected by the Senate through a disallowance, obviously requires that a large number of related party payments are disclosed, right? I mean, wasn't that the policy basis for pursuing this regulation that was disallowed?
Sorry, Senator, what was the purpose of the disallowed regulation?
I'm just trying to understand. So, I mean, as you know, we're talking about a particular bill here, but as you can see from the industry submissions and your evidence today, I mean, we're talking about disclosure of information by super funds. We're cutting across the terrain of different elements. And I guess I'm asking you whether, is this going to align with the regulation that was made in the last Parliament, related party transactions?
I'm not sure exactly what you mean by align. It'll be complementary. This is additional information that will be required to be provided to members, and it will have some information about related parties. It will not, as you'd be aware, that Australian accounting standards do not require any sort of itemised disclosure of individual payments. So with that regard, like it's not like for like or anything like that.
Okay. Now, you have to forgive me, it's a while since I've looked at how the accounting standards arrangements, the mechanics work, but I mean, the AASB makes the superannuation accounting standard, right?
That's correct, yes.
Okay, so what is this?
This is the obligation for superannuation funds to provide ASIC the information and also require them to make it public on their website along with directors' things. So it's that aspect of it.
Okay, so this, because I'm not always particularly clever, I'm just trying to piece it all together. So the accounting standard is the accounting standard. They've got to do that anyway because they're captured as an entity. But this requires them to make effectively a public disclosure of that information. And then separate to that, there is the reporting obligations under the Your Future, Your Super reforms that were passed in the last Parliament, which require the funds to make a separate disclosure to members in their annual statement.
There's a lot of things going on in super, Senator. I definitely agree. Yes, this bill is basically around obligating superannuation funds to provide annual financial statements in accordance with the Australian accounting standards to ASIC and also on their website. That's probably the short version. There was the Your Future, Your Super suite of changes, which included the performance test obligations, and there was some disclosure. If you fail the performance test, as you know, you had to write to members, so there's some disclosure going on there. There's also the comparison tool in the ATO website, so there's some disclosure.
Very good.
Very good, yes. There's also the BFID, Best Financial Interest Duty pillar, and also the stapling regime as well. That was sort of the Your Future, Your Super regime. In addition to that, there was also the regulations that you were talking about, which is the annual member meetings regulations, which, as you know, were originally introduced by the previous government, and amendments were made by this government, and that was the regulation that was disallowed. So that was, there's lots of, and they're all, I want to say...
but it's, okay, so that's clear. So what about this statement the Minister made last year about a super transparency report? What's that?
I can just give you a sense. There was a three-part package of the transparency package announced as part of, I think it was the introduction of this particular bill, and there was three parts of it. The first part was effectively this bill. So this is financial reporting and auditing, and I suppose that's the this bill, and also there's some subsequent regulations that we're working on at the moment. So that's the first part. The second part is the superannuation transparency report, and this is, as you know, there's lots of work being undertaken by APRA at the moment to expand and improve the data that it collects under its superannuation data transformation project, and so that's largely a process that APRA is getting the data for at the moment, and going through quite a process on that. And then the third part is ongoing transparency reform, which is, I expect, where we come across, or where the Minister considers there's a need to ensure that additional regulations to make sure there's all the gaps in the transparency sort of system need to be amended. There may be future regulations in that sort of space. So that's the third sort of step, or phase, I should say.
Okay. But my final question is, I mean, we had the Minister Gallagher at Estimates last week make statements to the Parliament that the attempts to change the member statement regulations have been abandoned by the government after the disallowance. So does that mean that the existing regulation, which requires a high level of detail of disclosure of related party transactions and the like, that is the ongoing position that you're recommending?
If I wouldn't want to... Senator Gallagher is more important than me, Minister. I expect that her answer is the correct one.
Yeah, okay. Thanks.
Thank you, Senator Bragg. Thank you, Mr Spear and Mr Healy. We appreciate you being here today to answer our questions.
Thank you.
Committee's agreed that responses to questions on notice should be provided by close of business Thursday, 23 February. I now welcome representatives from the Smart Energy Council and representatives from Energy Networks Association. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, would you be able to unmute yourselves and turn your cameras on, those of you who are online?
That's me.
One of you online, thank you. That's Mr. Adams, is it, online? Yeah.
Yes, Dominic Adams.
Okay. So thanks for identifying yourself, Mr. Adams, and to Mr. Smith and Mr. Crawford. Apologise for getting a bit ahead of you there. I thought everyone was online for a moment there. And we're just looking for another nameplate, are we? Wolf? Thank you. Okay, so perhaps starting from my left there, Mr. Crawford, if you could just say your name and who you're representing today.
Sure. Garth Crawford, a General Manager of Economic Regulation at Energy Networks Australia.
Wayne Smith, I'm External Affairs Manager with the Smart Energy Council. We're a peak independent body for the renewables industry. Thank you.
Smart Energy Council, Connor Wolf, Policy, Legal and Research Advisor on energy reform.
Great. Thank you all very much for being with us today and accepting the committee's invitation to come and give evidence, particularly in relation to Schedule 8 of this bill. Did anyone have an opening statement that you wished to give? Mr. Crawford. Thank you.
Thanks for the opportunity to speak to the committee today and to present on the inquiry into the Treasury Law Amendments Bill 2022. My colleague Dominic Adams, who's online, and I are here today representing Energy Networks Australia, the peak national body representing electricity and gas distribution and electricity transmission businesses in Australia. So our comments today, as you mentioned, focus on the amendments in Chapter 8 of the bill, further enabling the Clean Energy Finance Corporation to continue to actively support the transition to a clean energy future. Electricity transmission businesses that build, own and operate critical infrastructure links, the highways, if you like, of our electricity system, particularly welcome the continuing ongoing role that the CEFC can play in enabling new links and upgrades to be made in a timely way, underpinning greater competition and putting downward pressure on electricity prices. The transition to clean energy is one of the defining challenges of our time. It's what we will be judged on by future generations. Our electricity networks play a critical role in this transition by enabling the connection of new renewable energy generation and facilitating the efficient and reliable distribution of electricity. Strongly interconnected and resilient electricity networks also support the uptake of new technologies such as battery storage, electric vehicles and other distributed energy resources. Transmission has been identified across the world as playing a key part in this transition. As has been observed, there is no transition without transmission. Poorly interconnected state-based markets will impose higher costs and degrade energy security and reliability for customers. The rapid transition to a clean energy future is challenging, and we need to make significant investments in our electricity infrastructure to achieve the goal of energy transition. And the pathways identified by the Australian Energy Market Operator in its Integrated System Plan. The Integrated System Plan modelling shows that every dollar spent on new transmission pays itself back twice over. We also know that delays to transmission will push up costs to customers. That's why the CEFC and the role it can play is so important. The CEFC, with its expertise and focus on clean energy, in combination with the Rewiring the Nation commitments, can play a significant role in helping to finance the transition and facilitate it. A significantly greater role for CEFC funding in our sector will bring about a range of benefits, including supporting project financing, unlocking private sector investment, encouraging innovation and supporting regional development and jobs. CEFC support to unblock some of the financing investment challenges is a good practical step to supporting the transition to a net zero emissions on the ground. You can't connect renewables without a cable to connect into. And getting the finance investment situation squared away means that businesses can get on and deliver. These tangible actions, like securing workforce arrangements, locking in contractors, purchasing long lead time items like cables and transformers that we are competing on with every other transitioning energy system, is critical. We are confident that the flexibility and additional CFC funding in this bill can better achieve the goal of a cleaner, secure and more affordable energy future for Australia. In conclusion, we strongly support the flexible enabling of CFC funding for transition that this bill allows for. We think it will bring about significant benefits to the community, the electricity sector and the whole economy. We look forward to working with the CFC and all Australian governments to achieve this goal. My colleague Dominic and I are happy to answer any questions you have on our comments and perspectives. So thanks again for this opportunity.
Thank you very much, Mr. Crawford. Mr. Smith. Yep.
Sorry, if I may make some
please.
opening comments as well.
Yep.
Look, I actually just want to take the opportunity just to congratulate and put on the public record from a Smart Energy Council's perspective. Look, our congratulations to the Clean Energy Finance Corporation for 10 years of achievements. It's managed to deliver over those 10 years something like 5 gigawatts of additional solar and wind. That's an extraordinary achievement. And the Clean Energy Finance Corporation has really been one of the great Australian institutions in driving climate action and investment in renewable energy as well. I just want to put on the public record, in particular, our congratulations and thanks to Oliver Yates, who was the inaugural CEO of the Clean Energy Finance Corporation and was CEO for the first 4 years. He's now a director, board member for the Smart Energy Council. And really, those first couple of years or so were really tough years. The Clean Energy Finance Corporation was under very significant attack from the then Abbott opposition and the then Abbott government. There were numerous attempts to actually abolish the Clean Energy Finance Corporation. I really want to pay tribute to the work that Oliver Yates did, the courage that he showed in standing up to the then Australian government and in defending the Clean Energy Finance Corporation. And also congratulations to John Grimes, who's the CEO of the Smart Energy Council, who really led a really strong campaign to actually protect the Clean Energy Finance Corporation. And we're now seeing the results of that with over 5 gigawatts of investment in renewable energy. It's also worth noting that the Clean Energy Finance Corporation is now seen as a great model for how investment should happen in other institutions. And a classic example of that was, in fact, the announcement from New South Wales Labor, the New South Wales opposition on Sunday, on this weekend, where it announced a new $1 billion Energy Security Corporation, which is a proposed public institution that uses the architecture of the Clean Energy Finance Corporation to really provide investment in medium and long duration energy storage. So the Clean Energy Finance Corporation is recognised right around Australia as a really strong model for how these sorts of institutions should operate, and again recognising that it's off budget as well. The Smart Energy Council supports this legislation. In our submission, we've proposed a number of reforms to the investment mandate for the Clean Energy Finance Corporation, recognising that it's 10 years old now, recognising that the energy transition is really happening at great pace, and there's ways in which we think we can modernise and sharpen the investment mandate for the Clean Energy Finance Corporation. Thank you.
Thank you very much. Thank you, Mr. Crawford and Mr. Smith, for those opening statements. Just sort of off the bat, it sounds like you're very supportive of the Clean Energy Finance Corporation and also of the measures of this schedule, but I'll just ask you to clarify whether you essentially support funding the CEFC to implement the Rewiring the Nation plan and also establishing the Powering Australia Technology Fund. Mr. Crawford.
We do.
And Mr. Smith.
Yeah, we do. We're certainly strong supporters of Rewiring the Nation, but we think also, in addition, there is a need for a need to really prioritise investment in renewable energy storage at all scales. Look, we're not going to get to 82% renewables by 2030 unless we really significantly unlock investment in renewable energy storage. Our view is that we need, when it comes to renewable energy storage, we need everything, everywhere, all at once, again and again and again and again, and that means everything from household battery storage to community batteries to large-scale energy storage, pumped hydro, solar thermal, and everything else. And we think there's probably a fair bit more that the Clean Energy Finance Corporation can do to help unlock that investment in renewable energy storage.
So it's your submission that it's important to update the grid and urgent to update the grid, but to reach our targets, we also have to invest in additional storage of the kind that you've just articulated.
Yeah, that's right, Chair.
This particular schedule, designates the CEFC as the funder for rewiring the nation in particular. Do you find that the CEFC model is a trusted model for this type of financing arrangement? Mr. Crawford?
Yeah, we found it to be a very effective mechanism, particularly as these large lumps of transmission investment have to occur, which really haven't occurred over the past decade or even 2 decades. These are significant capital resources, and so CFC funding and guarantees, for example, were essential in getting the Transgrid Project Energy Connect project across the line and commissioned into that sort of final investment decision. So we see lots of opportunities for the CFC's financing, but also its guarantees and other innovative things it can do to make that ISP actually happen.
Yeah, we certainly do. And again, the fact that it was referenced on the weekend by the New South Wales opposition in its announcement of the $1 billion Energy Security Corporation shows that that model really works. This isn't a party political thing. So the New South Wales government, for example, has consistently referenced the Clean Energy Finance Corporation as a very good model. And we would encourage that. We think that sort of model also can work around other measures, the National Reconstruction Fund, for example. There's a whole range of bodies which could potentially be modelled around the Clean Energy Finance Corporation.
Okay. And why is the independence of the CEFC important in this kind of funding arrangement in driving the financing of the shift to renewable energy? Why is their independence important to that?
I mean, I think I might make a start on that and perhaps throw to my colleague Dominic for a moment to add anything that I've forgotten. But I mean, I think it's really important that projects aren't seen as sort of in the political gift of particular governments, that somebody stands back and rationally assesses what can we do to maximise this project, which in the case of integrated system plan projects are projects which are already identified as having benefits outweighing the costs. It's really important that somebody sort of steps back and before financial resources which ultimately flow from taxpayer are committed, that decision is sort of on a standalone basis. Dominic, is there anything you should add?
Yeah, I think broadly it also is a process that adds much greater stakeholder confidence around the whole broader social licence for these projects, that they are the right projects to invest in, having that measure of independence. The other key is that it's about the expertise of the people who are undertaking the real on-the-ground task of working out what are the financing gaps, what are the particular needs of this project, and they are very different across the different types of projects. So CEFC does a lot of work behind the scenes on the ground with individual organisations to work out what's the gap they're trying to bridge here, trying to make sure that they're not bridging more than the gap and they're filling the gap so that private capital can come in and do its job and do the rest of the financing, so that they're really just unplugging or uncorking the blockage that gets this to flow. And those decisions are really best made by an organisation with the expertise at hand, like the CEFC.
Okay. Thank you very much, Mr. Adams. How do you expect that this sort of rewiring the nation investment into grid infrastructure will assist the energy transformation that we need to undergo?
Look, from my perspective, and from Smart Energy Council's perspective, in some ways it's everything. Like, you don't get to 82% renewables without rewiring the nation. And so it's a fundamental project. It's a nation-building project, really, and it'll drive that transition. So I really commend the Australian government on the initiative.
Thank you. Did you have something to add, Mr. Adams, there, or?
Yeah, a little bit of colour maybe is that if we were trying to design the physical power system that we need in the future to be net zero, we really wouldn't start where we are today. You'd be designing a completely different system, and the level of investment that is required to get from where we are today to where we need to be causes significant challenges. So, what we're hearing from the businesses, our challenges are workforce, our challenges are supply chains, our challenges are competing with procuring 20, 50 large high voltage transformers and competing with America, competing with businesses in Europe. So once you lock in the financial settings and you give that certainty and you have that comfort that the government has your back through rewiring the nation, you can start to unplug some of those blockages. You can start to make sure that the transition happens here, and that, you know, the customers in Australia, and the energy is one of the three largest inputs into a smooth running economy. There's energy, and there's labour, and there's capital. And if you can get, if we can do our best to compete on that front, it helps set Australia up pretty well.
Thank you, Mr. Adams, and Mr. Smith wanted to make some additional comments.
If it's okay, just to make an additional comment, we've obviously expressed very, very strong support for rewiring the nation. But it's also true that energy isn't just big infrastructure projects around the country, lots of poles and wires. It's also local energy. And so we are seeing increasingly rooftop solar on homes and in businesses around the country, playing a more and more critical role in the energy mix. So something like, you know, up to 20% or so of the energy generation in Australia comes from rooftop solar. The projection is it'll get to 40%, 50% before not too long, in fact. And so it's also critically important that attention is focused on that rooftop solar, household solar, and how do you maximise the opportunities from that as well. So it's separate to the discussion about rewiring the nation, but it's complementary to the discussion as well. And we'd certainly encourage the Clean Energy Finance Corporation, the Australian government, to put perhaps almost as much attention into rooftop solar, household solar and battery storage as it does into big grid infrastructure projects as well. Thank you.
Okay, thank you. Mr. Wolf.
Thank you very much. On back to the topic of rewiring the nation, and I guess the colleagues here have outlined why we need a significant investment in infrastructure. The reason why I think it's so important that it goes into a body like CEFC to manage that, advised by AEMO Services, is that for the past 10 years we've had really large transmission projects being developed, such as the project from South Australia across to Victoria, and Project Energy Connect. That's had maybe 5 to 6 years of delays in a regulatory system which has been widely sort of admitted that it's not fit for purpose, and that's why every state's now developing renewable energy zones to bypass that, what can be considered broken regulation. The government then stepped in after about 5 or 6 years of that project and added, I think, between $100 and $200 million in, I can't remember the exact mechanism of the fund, but it was some sort of grant. And so what this shows is that these projects are too important to fail. The government comes in and steps in and provides the required funding at the end of the day, but leaving it to the private investors and private market alone, we're seeing serious delays, and then government steps in anyway. So the CEFC I guess, should avoid that issue by having the support from the Australian Energy Market Operator and AEMO Services and the direct funding to make these projects occur in the timeline that we need them for 82% renewables by 2030. Thank you.
Yeah. Thank you, Mr. Wolf. So, sort of to try and paraphrase what you've said there, given the importance of upgrading the energy grid for the renewables that we need, it's important that we have an independent body that's, government-backed, that's got a proven track record of cutting through the sorts of challenges that you just described to actually get the investment in the grid done and done quickly.
Yeah, and just to add to that, the current private sort of regulation looks at a very narrow test of benefit, whereas providing public, a public backing of these projects allows the investment to consider the broader public good to these projects, which not only support lower bills, but also enable an industrialisation of many of Australia's emerging zones.
Okay.
Thank you.
Great. I think that's actually all the questions that the committee has for you. And it seems we've got more witnesses getting ready to join us at the same time. So we thank you very much, Mr. Crawford, Mr. Smith, Mr. Wolf, and also Mr. Adams. We really appreciate the evidence that you've given us today. The committee's agreed that responses to questions or notice should be provided by close of business Thursday, 23rd of February. Mr. Adams, we invite you to disconnect from the hearing, and if you'd like to follow along, you can do that through the live stream on the website. But to all of you, thank you very much for your evidence today. Thank you.
Thank you. Thank you, Kim.
The committee will take a 5-minute break. Welcome by video conference representatives from the Clean Energy Finance Corporation and representatives from the Department of Climate Change, Energy, the Environment and Water in person. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, perhaps starting here with the people in the room, would you please state your full name and the capacity in which you appear today?
Paul Johnson, Principal Advisor, Electricity Division, Department of Climate Change, Energy, the Environment and Water.
Thank you, Mr. Johnson.
Kirsty Gowans, Head of Electricity Division, Department of Environment, Energy, Climate Change and Water.
Shane Gaddis, Head of the Adaptation and New Industries Division, same department.
Paul Murphy, Branch Head, Offshore Renewables, also with DQ.
Thank you. And going to you, Mr. Learmonth. I think you are off mute at the moment, so if you just wanted to introduce yourself, I think we should be able to hear you. Mr. Learmonth.
I'm having a sound challenge on my side, I'm afraid.
So you can't hear us, we can hear you. I think that would be a volume down issue, I think. I suspect, Mr. Every, that Mr. Learmonth just has his volume down on his device if you're able to communicate with him.
I will pass that through.
And at the same time, perhaps Mr. Every, if you introduce yourself just for Hansard.
Simon Every, Clean Energy Finance Corporation. I'm Head of Government and Stakeholder Relations at CEFC.
Okay, thank you. I'll start my questions with the department, and then I'm not sure whether the Secretariat will provide some assistance. Secretariat will provide some assistance in relation to Mr. Learmont's sound issues, but I'll start with those of you who are in the room. How will the Rewiring the Nation plan get more energy into the grid and assist with our Paris targets?
Senator, Rewiring the Nation program will provide $20 billion of low-cost finance support to major transmission projects across Australia. By bringing on the construction of these projects, it will enable renewable energy generation and storage projects to connect to the grid, and that will allow the removal or the exit of coal-fired and other fossil-fuelled sources of generation from the grid, thus reducing emissions.
And how critical is Rewiring the Nation as part of all the measures that we have to do this transition to renewable energy? How important is this particular Rewiring the Nation plan within the context of the transition in general?
So if I refer you to the Australian Energy Market Operators Integrated System Plan. This is a plan that it releases every 2 years. The last edition came out in the middle of last year. It looks forward to 2050 at the least cost system needs to supply energy. And that shows a massive need for investment in renewable energy generation, something like 9 times the current capacity of variable renewable energy that has to be brought on. It is necessarily the fact that that generation cannot be built in the current locations where major generators are located. It needs to be built in locations where there are solar and wind resources. And to bring that power to the market, it needs transmission. So that cannot happen without an investment of a large scale in transmission across the East Coast, and similarly also in WA and the Northern Territory.
Okay, thank you. And what Schedule 8 of this bill does is, make the decision that the way the Rewiring the Nation plan will be funded is via the Clean Energy Finance Corporation. Why is the CEFC the appropriate body for Rewiring the Nation, to finance Rewiring the Nation?
Well, Senator, the Clean Energy Finance Corporation has already, from its existing resources, funded a number of transmission investments, as well as a much broader range of investments in the clean energy space. So it has experience in this sector.
Okay, thank you. How are we going with the representatives from the CEFC? Do we have you, Mr. Learmonth? If not, I might just proceed with a few questions for you, Mr. Every, if that's appropriate.
Fire away.
Okay.
We'll do our best. If not, I'll have to take them on notice.
Okay. How is the CEFC already investing in upgrading energy infrastructure to support renewable energy sources?
So perhaps the largest investment that we've done to date was the $295 million that we committed to effectively triangulate the grid from South Australia to New South Wales by supporting the Project Energy Connect transmission line. So that's the largest example, if you like. But we have also supported other projects such as, transmission that's associated with Snowy 2.0 as well. And if you look to items like storage and its role in supporting the grid under an environment where there's more variable renewable energy in the system, we're also looking at, we have also supported developments like the Victorian Big Battery and the South Australian Hornsdale facility.
Thank you. So what will the allocation of funding in Schedule 8 for Rewiring the Nation, what will that allow the CEFC to do?
Basically fund more of it. Prior to Rewiring the Nation, there was, under the previous government, a proposal to provide the CFC with an additional $1 billion in new capital to commence some of the works that are required to be done urgently on the system for support. And this is a larger amount, if you like, but it is to be used for the same purpose, to go and get on with the job of connecting Australia to the parts of the country where the cheapest renewables resources are, and interconnecting the various grids a little better to improve the flow of electrons.
Okay. How will this boost to the work that you do and the next steps of the Rewiring the Nation plan? How will that help ensure that Australia meets its Paris climate targets?
I'm happy to field that one if you like. Thank you. Sorry about the tech issues. Nice to be back.
Welcome. Good to have you.
Thank you. I mean, obviously the government has has a policy and a plan to get to 82% renewables by 2030, and by, of course, decarbonising the electricity sector, the largest, where a third of our emissions come from, will be a very significant contributor in our plans to get to net zero and comply with the Paris Treaty. So the Rewiring the Nation capital, the money that would be appropriated in the projects that we would support and invest in, will unlock renewables and accompanying storage, both battery storage, large-scale pump storage, to enable us to get to that high level of renewables penetration to ultimately decarbonise the electricity sector.
Okay. So in addition to decarbonisation and making sure that we meet our targets and that we're able to get these sources of renewable energy into the grid, are you able to share any information about how the Rewiring the Nation plan would have impacts for jobs and for workforce and for skills, or is that slightly outside of your purview?
It's a consideration in the course of what we do. I mean, I guess it's fair to say that this enormous investment in transmission infrastructure and accompanying storage and grid security will no doubt create a very significant number of jobs, and develop the skills of a workforce that is critical to the clean energy transition. So it certainly will be a major contributor to employment across the country.
Okay, thank you. And just final question. Final couple of questions from me. Why is the independence of the CEFC critical for this type of financing arrangement?
Well, the CEFC has had, since establishment, has, under its Act, been in a position where it has had independence in terms of its investment decision-making. And that's held it in very good stead. It means it's making decisions on the merits of the elements of the Act and the investment mandates that it's been given over from time to time. As I say, that has served its well in terms of the transactions that we've done, the impact that we've had, and the financial success, as well as the as the impact that we've had in terms of decarbonising the country and accelerating the clean energy transition. So we would, we would see that that's an important an element to the CFC, and I think under the additional capital that will come via Rewiring the Nation, I think that's also an important element to have guiding us, that we are effectively independent from day-to-day government decisions, and we are we're making decisions on investments on their merits, really in line with the directions that we've been given.
Thank you. And does this schedule in the bill, Schedule 8, restrict or impact the independence of the CFC that you've just outlined in any way?
I may have missed just the first part of that, the Schedule 8. You mean Schedule 8 is the whole appropriation
Yes.
relative to the CFC?
Yeah.
I mean, it is fair to say that Rewiring the Nation does have a very clear objective and direction, but I don't believe that our kind of sense of independence in terms of final investment decisions around projects will be compromised by Schedule 8.
Yeah, thank you. So it's consistent with how the CFC, has been operating, in the sense that there's a clear objective from government, but the financing and investment decisions are made independently by your body.
Correct.
Okay. Thank you. Just got a final question, which is for the department, which is what does the rollout of Rewiring the Nation mean for consumers of electricity?
So the Rewiring the Nation policy is directed at keeping the cost of the energy transformation as the least cost to consumers by the least cost model. So leveraging the balance sheet of the Commonwealth and providing low cost debt means, first of all, that we bring on the renewable energy more quickly. It accelerates the delivery of these projects, providing financial investment decisions and certain decisions earlier. So it brings those projects on in a timely way, and those projects unlock least cost renewable energy for Australian consumers. But secondarily, the low cost debt, particularly in some cases, reduces the overall financing and project cost of very large transmission projects. Because the cost of finance is a significant element to the total project cost. And if that financing cost is reduced, the costs that flow through to consumers through their network charges, network system charges, is actually significantly less. So by leveraging that Commonwealth balance sheet to do that, we can lift the burden on consumers and make the renewable energy transformation happen at the lowest possible cost to Australian consumers.
Okay, thank you, Ms Gowans. I believe that concludes the questions that we have for you. It concludes my questions. I'm just giving a final shout out to other senators there and just confirming that does conclude our questions for you. So thank you all very much for appearing as witnesses today. We very much appreciate your evidence and your input into the inquiry. The committee has agreed that responses to questions or notice should be provided by close of business Thursday, 23rd of February. For those online, I'd ask that you now disconnect from the hearing. And again, you go with our thanks. We really appreciate your attendance today. Thank you.
Thank you.
That concludes today's hearing. Thank you to all witnesses who appeared and to Hansard and Broadcasting for their assistance. Again, the committee has agreed that responses to questions on notice should be provided by COB Thursday, 23rd of February 2023, and the committee stands adjourned. Thank you. Thank you very much.